Welcome back, everyone. We are now on item 11, announcements. Councillor Gibson.
Thank you, Madam President. There will be a Winrock Tax Increment Development District Board of Directors meeting on Monday, August 12th at 1:30 in the Council Committee Room on the 9th floor.
Councillor Benton.
Thank you, Madam President. There will be a Land Use Planning and Zoning Committee meeting on Wednesday, August 14th at 5 p.m. in the Council Committee Room on the 9th floor.
I will read Councillor Harris's. There will be a Finance and Government Operations Committee meeting on Monday, August 12th at 5 p.m. in the Council Committee Room on the 9th floor. I'd like to make one additional announcement, hoping people from the community will go out and support Isotopes. This will be their final mariachi game of the season on August 11th at 6:05, and it will also be lowrider night. So hope to see everyone there. Next item is item 12, public hearings. We have AC 19-6, Thomas Goley and Hessel Yetema III, agent for Taylor Ranch Neighborhood Association and surrounding property owners, appeal the Environmental Planning Commission. Mr. Melendez, can I just kind of read these two together and we'll hear them out together? Is that fine?
Madam President and Council, yeah, you may hear them together. I think it might make sense because the issues in each appeal are a little bit different. If you were to hear from Mr. Gully on his appeal 19-6 and then allow the applicant to rebut the issues in that appeal, and then hear from the Taylor Ranch Neighborhood Association in 19-7, and then again allow the appellant to rebut that
Okay,
appeal.
so I can read that we're on both appeals, and then you can just guide me if I mess up a little bit
Madam
here.
President, correct.
Okay. And then we have B, AC 19-7, Thomas Goley and Hessel Yetema the third, agent for Taylor Ranch Neighborhood Association surrounding property owners, appeal the Environmental Planning Commission.
Madam President, I also want to note that the clerk of the council today did receive a letter from the Taylor Ranch Neighborhood Association authorizing Miss Susan Schauder to represent them in the appeal tonight. I'm not sure if Mr. Eintema will be here, but if not, Miss Schauder sounds like she will.
Can you say the name again? I'm sorry.
I'm not sure if I'm pronouncing it right, but I believe it's Dr. Susan Schauder, Chardois.
Okay.
That's for AC 19-7.
Okay. So, Mr. Melendez, can you explain the appeals, please?
Madam President and Council, this is a full hearing of an appeal that you first heard at your last meeting in June. It relates to the pool property on Albuquerque's west side and the proposed development of a cluster development site at that location consisting of 76 lots on 23 acres. In the case of cluster developments, the minimum lot size may be reduced in exchange for the preservation of open space. In this case, they're proposing lots from 5,500 square feet to 12,000 square feet. The EPC approved that cluster proposal. However, it was appealed by two separate appellants, Mr. Gully and by the Taylor Ranch Neighborhood Association. At your last meeting in June, you rejected the recommendation of the land use hearing officer, who was recommending that both appeals be denied and that the EPC acted appropriately. And tonight we will hear from the parties in order to argue their case before you relevant to the appeal.
Thank you, Mr. Melendez. So I'll go ahead and read this into the record. I'm assuming I need to do that. All presenters, other than the attorneys, must be sworn in. The parties are allowed to cross-examine one another. All those who will testify, can you please stand and raise your right hand?
Madam President, I am an attorney, so that's why I'm not raising my right hand.
Correct. I had to make that assumption. Thank you. Do you swear to tell the truth?
Yes.
Okay, thank you. The time limits for the presenters are as follows. AC 19-6, 8 minutes, presentation from the appellant. B, 10 minutes, a presentation from the appellee. 3 minutes, presentation by or response to questions by city planning staff. D, 2 minutes, rebuttal by any appellant, if any. On AC 19-7, there'll be 8 minutes presentation from the appellant. B, 10 minutes presentation from the appellee. C, 3 minutes presentation by presentation by response to questions by city planning staff. And then D, 2 minutes rebuttal by appellant, if any. Then deliberation and discussion amongst the counselors. So we will get started, and I'm assuming this is Mr. Thomas?
Gully.
Gully?
Tom Gully, yes.
Okay.
Before I start, I would ask that someone from city staff pass out the exhibits I have for each of the counselors.
Madam President, could Mr. Gully please describe the exhibits that he's passing out? We have limitations on new evidence, and we want to clarify whether or not this is material in the record or what the nature of it is.
No, the only exhibits are from the IDO and from the Lujo decision and from the site plan, all in the record.
Madam President, the IDO is incorporated by reference in all of these appeals, and the other material appears that it's already in the record, so it's appropriate to distribute those. However, I would recommend that a copy also be distributed to the appellees, the developers in this matter, so that they can follow along.
Thank you. Here's one for, you already have one. I'll pass it to Mr. Strozier. Here's one for the city staff. And I have one more if anyone would like it.
Okay, I think it's, go ahead and get started. Thank
Okay.
you.
Thank you, Madam President and councilors. My name is Tom Gully. I'd like to clarify one thing. I'm the sole appellant in 1906. Only I, as a retired lawyer, a very retired lawyer, representing only myself, am the appellant. My appeal issue is that whether multiple cluster developments are allowed on the pool property site plan. The answer is they are not. In effect, this multiple cluster site plan is really one big single cluster masquerading as two. The standards for ordinance interpretation were addressed in the Supreme Court case of High Ridge Hinkle versus City of Albuquerque. In that case, the Supreme Court found that the city was reading language into the zoning ordinance which was not there. So the city lost that case. The standards in High Ridge Hinkle are that if the language makes sense as written, it applies. And zoning regulations cannot be construed to include by implication that which is not clearly within the regulation's express terms. So let's look at Exhibit 1. Could I have the overhead turned on, please? Exhibit 1 is the, how do I do this? This way? Okay. Exhibit 1 is the table of allowable uses, which provides that dwelling cluster development singular is allowed in an RA zone. Then Exhibit 2, page 1 of Exhibit 2 is the start of the cluster development regulations at the bottom. And then on the next page, page 2 of Exhibit 2, you see subsection D, which provides the cluster development singular project site, and subsection E, the cluster development, singular, shall be designated on a site plan. It's clear from the express terms of the cluster development regulations that only one cluster development is allowed. Turning to my Exhibit 3, this is a page from the Lujo's decision. In it, the Lujo states, I agree with the appellants that the site plan reviewed by the EPC at its March 14, 2019 hearing, without the modifications ordered by the EPC, is in form and substance a single cluster development that exceeds the allowed number of dwelling units allowed under the IDO. There, it's talking about the 50-lot limitation for a cluster development. And the only reason the developer wants to have 2 clusters is to get around that 50-lot limitation. Then the EPC, the LUHO goes on to say, if the EPC had not adopted its condition number 5 relating to setbacks, the EPC would have erred. There, the LUHO is saying, but for condition 5, Mr. Gully would be correct, that only one single cluster development is allowed on the site plan. Now, what is condition 5? First, let's look at a page from the EPC's decision. There it states, the applicant proposes 2 cluster developments which is permitted in the subject RA zone. That decision is independent of anything else in the IDO. The EPC found that multiple cluster developments are allowed. It did not tie it to anything. And then in condition number 5 of the second page here on Exhibit 5, in the conditions of approval, there's where you have Exhibit 5. Setbacks at the perimeter of each cluster are required to be per the underlying RA zone district as follows. And there the setbacks are front 20, side 10, minimum 25. Why did the EPC add condition 5? That's because if you look at a portion of the site plan enlarged, the applicant has setbacks in lots C1 through C72, which are less than the required RA zone setbacks. It has only 4 lots that meet the RA zone setbacks, lots 73 through 76. So the EPC in its decision said, okay, multiple clusters are okay, but you got to have RA setbacks for each cluster. The 2 are simply independent items. Whether multiple clusters are allowed is independent of the setbacks that are required in an RA zone. So it's interesting that the city staff, planning staff, before the EPC did not argue a condition would make the multiple clusters acceptable. Instead, the city argued before the LUHO that there's no prohibition in the ordinance that prohibits multiple clusters, and the city went so far to say this project could be treated as if it were 2 separate owners with 2 separate projects, or one owner with 2 projects on different properties. So if those can be adjacent to other, it is reasonably implied that multiple clusters can be adjacent to each other on the same project site. But you see the fallacy of that reasoning. We're not talking about 2 separate owners or one owner with 2 separate properties. We're talking about one project site with one owner, trying to get around the 50-lot limitation in the ordinance for cluster developments. In conclusion, I would ask the city council not to set a precedent. I would ask the city council not to set a precedent that language can be read into the IDO which is not there, which if you approve the LUHO's decision, you'll be doing exactly that. I would ask the council to grant my appeal, reject the LUHO's decision, and make a finding that only one cluster development is allowed on the pool property site plan. Thank you very much.
Thank you. Please, no applause.
No applause.
Next is a presentation, 10 minutes from the appellee.
Thank you, Madam President, members of the council. My name is Jenica Jacoby, and I'm an attorney with the Rhodey Law Firm here on behalf of the appellee's Gamma Development. I'm also accompanied by Mr. James Strozier. The sole issue in this appeal is whether or not a plan can contain 2 cluster developments. As we'll describe, not only can a site plan contain 2 clusters, but this clustering is consistent with the comprehensive plan's goals for this area and creates the best designed product for this and the adjacent major public open space in this area. As Mr. Melendrez described, cluster development creates more open space by allowing slightly smaller lots on a property. It's greatly encouraged by the comprehensive plan. And in this case, that sounds a little scary that the lots would be smaller, but the lots created here actually are very comparable to the surrounding area. This subdivision that's proposed is going to be very comparable in size and quality to the surrounding Oxbow neighborhood. The New Mexico courts reject a formalistic and mechanical construction of statutes when the results would be absurd, unreasonable, or contrary to the point of the statute. Nowhere in the IDO does it say that you can't have 2 clusters. And I strongly disagree with Mr. Goley about precedent here, because to me the dangerous precedent to set is implying a restriction on private property that's not in the IDO. I think that's a very dangerous precedent to set, that I'm reading the code, it doesn't say you can't do this, but I think if you squint and look at these words, I'm going to imply a restriction. I think that's very scary for development in the future of construction in Albuquerque. But this proposed interpretation does lead to an absurd result. As Mr. Goley alluded, you actually could construct these properties side by side and get this exact same result if you just did 2 different site plan applications. And my client, in fact, could do that. The property right now is made up of multiple parcels, and it's being replatted to allow this development. And instead of doing it on 1 site plan, that could easily be done on 2. Part of this site plan needed to go to EPC because it's within a certain distance from major public open space, and part of it didn't. But it made sense to my client in the planning department to consider it as a whole, so that you could look for the best result possible for the development in the adjacent sensitive lands. But to say, because you did that, so that we could look at the project as a whole and try to come up with the best overall solution, now you can't do 2 clusters where you could have, if you simply split that application in 2, which you could do, is absurd. It's a waste of time. It's not a proper construction of the ordinance to say that that's the proper interpretation. That really elevates form over substance. The appellants rely heavily on the table 4.2 and the use of the singular term cluster development. This reliance is misplaced because all of the uses there in table 4.2 use the singular form. For example, dwelling, mobile home. No one's going to think that you're only going to have 1 mobile home or 1 mobile home development in an area. Those are obviously going to come in groups and clusters. Yeah, I shouldn't use the word cluster since that's a defined term here. But those are never going to come in the singular and are clearly allowed in the plural. And the Lujo actually noted the IDO uses the plural term, cluster developments. And so there's really nothing to be implied here in the ordinance that something's intended by the use of the singular in certain sections. It doesn't imply that you can't use the negative, it's used elsewhere. The number of dwelling units for each cluster is limited to 50. This section could have easily limited adjacent cluster developments or used a defined term such as site plan to say we intend to limit 1 cluster to a site plan. This isn't contained in the IDO at all. The Lujo properly found, hey, each of these clusters meets all of the rules for a cluster development, including that setback that was shown. And that's going to be increased when the project goes to the DRB to make sure that each cluster is meeting all of those requirements in that full setback. The comp plan specifically calls to promote the use of cluster developments adjacent to sensitive sites like the Bosque. And that's because it buffers that sensitive space and it provides greater outdoor areas for the neighbors to enjoy. This project is actually creating 32% of the project site to be open space, over, I believe, 7 acres. And that's going to be located primarily next to the open space, as Mr. Strozier will describe, and really produces a quality result for this project that wouldn't be possible without the clustering. The initial application actually didn't have 2 cluster developments, but in meeting with staff and considering all of the feedback received, especially the feedback from open space, adding a second cluster simply produced a better result. Mr. Strozier will describe this further, supporting how staff and the LUHO's interpretation of this issue not only is consistent with law and the interpretation of the IDO, but it actually furthers the goals and objectives for which the IDO was adopted.
I don't know if we can turn on the overhead while I speak, but thank you, Jenica. So I think now that you've heard why this appeal should be denied on the technical merits, I want to discuss the reasons that having 2 clusters actually produces a better result. And as Ms. Jacoby mentioned, when we first submitted our application, we only had 1 cluster. And working with staff, and both in planning and open space, we actually determined that we could do a better job with this overall layout if we had 2 clusters. So the image that is up on the screen is the final site plan that was recommended for approval by staff, approved with findings and conditions by the EPC, and recommended to be affirmed by the LUHO. We have access to the property on the south. We have a large open space both on the east and south area. This area right here is actually a part of the wetland down below that is part of the San Antonio Oxbow. As recognized by the LUHO in his recommendation, the proposed design accomplishes the goals of clustering, which is to preserve open space and buffer the adjacent sensitive lands. He noted that the design allows for a large portion of on-site open space to act as a buffer to the San Antonio Oxbow major public open space, and the design also places the lowest residential densities in the area closest to the major public open space. The total open space created with the 2 clusters is 7.38 acres, over 32% of the property. By including both clusters on one site plan, the staff and the EPC was able to review the project as a whole. Once again, as Ms. Jacoby mentioned, it doesn't make any sense to see disconnected parts of the whole. So putting them on 2 cluster projects on one site plan actually enabled both staff to review it as a whole, EPC to review it as a whole, and make decisions accordingly as a part of this. The result is the 2 cluster projects work harmoniously together, side by side, to produce a cohesive neighborhood that does an excellent job of buffering the adjacent Oxbow and major public open space. The approach used with the 2 cluster designs was the result of a long process and numerous meetings and discussions with planning and open space staff with the goal of designing a neighborhood that provides the most open space, the best buffer to the major public open space, and creates a well-designed neighborhood for future residents. So we have, if you look at the site plan, we do have an interior open space. We've got an interior trail network that is created with this. We have pedestrian access to the north where the city's neighborhood park is. We have emergency access. We worked with the fire department to make sure that all of these issues were addressed for the project as a whole. And once again, over 32% of the property was left as open space. I might note that before we ever went to the EPC, we did look at doing a standard RA subdivision for this site. It did end up with less lots, slightly less lots, but no open space. Everything was part of somebody's lot, including the wetland, which is permitted. So with that, we would respectfully urge that you deny this appeal and affirm the EPC's approval as recommended by staff and as recommended by the LUHO in his recommendation. We appreciate it, and we'll be available to answer questions at your discretion. Thank you very much.
Thank you. So now we have a presentation or response to questions by city planning staff. 3 minutes.
Hello, Russell Brito from the City Planning Department. No presentation, but I did want to point out a couple of things in response to what you just heard. Ms. Jacoby correctly pointed out that all the uses in Table 4.1, allowable uses, are listed in the singular. And we agree that per the appellant's position, for example, a shopping center with commercial zoning could only have one general retail use, could only have one office, could only have one restaurant. But that's not the case. Shopping centers usually have multiple general retail uses, oftentimes multiple restaurants, and that's throughout that table. They are listed in the singular. The IDO does use the plural when it refers to cluster developments in 141654F3D. And the appellant also noted, if not for condition number 5, it would have been one big cluster. But the EPC did approve the site plan with its condition number 5 that mandated that the two clusters be clearly delineated on their exterior boundaries as required by the IDO to meet the RA zone setback standards. And with that, I'll stand for any questions if you have any.
Are there any questions from the council? Councilor Benton.
So, Mr. Brito, when we use the word site on any given property, not just this case, but when we use the word site, isn't that defined as a physical boundary with subdivision lines and property lines between developments?
Madam President, Commissioner Benton, yes, those are boundaries.
Normally, yeah, when
Yes.
we're looking at any given site for any purpose, whether it's a tiny site for a gas station or a site like this one, those are typically defined as having boundaries on all four sides. Or
Yes, it depends on the shape of the site.
circumscribed by boundaries, let's put it that way.
Yeah, it could be rectangular, it could be a trapezoid, it could be a pentagon, depending on the size and shape of the site. But as long as they're clearly delineated, they could be two sites on one site plan.
Sure.
But they need to have clear boundaries, yes.
Thank you.
Councilor Sanchez.
Thank you, Madam President. Mr. Brito, was there ever a declaratory ruling on this particular case?
Madam President and Councilor Sanchez, no, there was not a declaratory ruling, but the zoning enforcement officer did, on the record at the Planning Commission hearing, state his read of the integrated development ordinance, but no declaratory ruling was deemed necessary for this.
And also under IDO Section 5-2, Paragraph C, 1, page 198, there are issues in there in reference to the special lands. And under 5-2, Paragraph C, 1A, included in that is floodplains and flood hazard areas, steep slopes, unstable soils, wetlands, arroyos, irrigation facilities, acequias, escarpments, rock outcroppings, large stands and mature trees, and agricultural sites. Were those looked at in the preliminary hearing by the staff? And was those issues resolved or even looked at?
When the application first came in, we asked, where's the analysis? And there were, as you can see in the record, a few deferrals at the Planning Commission level, because we as staff were holding the applicant's feet to the fire, saying, we need more analysis. You need to detail these on the site plan, and you need to demonstrate how you're going to avoid these sensitive lands. So there were probably at least 3 deferrals of the case, anywhere from 30 to 90-day deferrals. because we were wanting that analysis to be done before the Planning Commission heard the case.
So were the issues resolved under those sections of the IDO?
Yes, they were resolved to our satisfaction, and hence we ultimately recommended approval with conditions.
Thank you.
Counselor Borrego.
Russell, thank you for being here tonight. So I have a question, and I'd like to go back to the site plan itself. Can we go back to the slide that showed the site plan? Is that possible, please? Thank you, Jim. Thank you. So, in looking at the site plan, that shows the 23 acres total, right? Is that what I'm seeing there? Just so I understand what I'm looking at.
Madam President, Councilor Borrego, yes, that's the
Okay.
entirety of the site.
And so you have 7.38 acres that is the cluster development? Is that what I heard earlier?
I
Is that
believe it was-
approximately 7.38 is actually the two cluster developments?
I believe the 7.3 acres is the on-site open space.
That's
That is
the
the
open
result
space.
of the cluster development.
That's the open space, okay. So the remaining acreage, I guess, is the 23 minus 7.38 is actually the two cluster developments. That contains the 100 lots. Is that right?
The remainder of the acreage are the developed portions or proposed development portions
Or the
for
two cluster
the houses.
developments, which are 50 and 50, right? Is that right?
Yes, the two cluster developments together.
Madam President, Counselor, I want to clarify that the record indicates that there are only 76 lots proposed. It's not 100.
76
Correct.
lots. Okay, I'm sorry, my mistake. Okay, so they said about a third of the property is open space?
That's correct.
And it's closest to the Oxbow? Is
The-
that what I saw on that site plan? That's.
The majority
Can you
of-
point out where the Oxbow is on that property?
The Oxbow is to
Where it
the
runs.
east and the southeast of the subject site.
Okay,
And the majority of the on-site open space is adjacent to the city's major public open space, but there's also some on-site open space on the interior of the development as well.
so those are common open space areas
Yes, for the residents.
within the development itself?
That's correct.
Okay. So, and Counselor Sanchez sort of asked the question about the sensitive lands and how we define that and how we kind of interpreted sensitive lands to this particular development. And I guess, would that have been up to staff to explain that to the Planning Commission? Or, I mean, how did we discuss that? You said there were several deferrals to discuss how the sensitive lands were going to be looked at, but kind of summarized to me how the staff interpreted the sensitive lands issue.
Certainly. The list of sensitive lands in 52C1, some of them are defined, some of them are not, so we had to consult with technical staff throughout the city, including the open space superintendent, the city forester, the city hydrologist, to weigh in on is that really a sensitive land? Is that steep slope really a steep slope? Are the unstable soils compactable, or do they have to be left as they are? We asked the city forester, what's a large stand of mature trees? And he provided his input about preserving some of the trees that are on the site.
Okay.
And so with this technical input from other city staff, as well as interaction amongst ourselves in the planning department. We provided the planning commission with as much information as possible for them to make an informed decision on this application.
Okay. Now, I just want to go back a little bit in terms of the comp plan, because that was mentioned earlier also in some of the discussion. What is the density that the comp plan recommends for this area?
I don't believe the comp plan has a density recommendation.
There's not a density limit any longer in the comp plan, like we used to have?
That's correct.
Okay, so that's a question in my mind. So let me ask you this regarding the site plan itself, because there is a question in my mind about the setbacks and how they relate back to the open space. And that's the question in my mind, actually, is how the setbacks, and there is common open space, and then there's the open space that's closest to the Oxbow. My question, I guess, is the standards that were shown in the EPC condition number 5, and regarding the setbacks, how did those come about? I mean, how were those arrived at to have that little chart that they have that have the setbacks specifically?
The setbacks for cluster developments apply to the exterior of the cluster development. So essentially, the applicant has to choose what's the front of your development. That has to comply with the front setback requirement of the RA zone. What are your sides of your cluster development? Those become the side setbacks. And what is the rear of your cluster development? Then that has to comply with the rear yard setback of the RA zone.
Okay, so every lot that's on that site plan had that same standard, correct?
No, the IDO says that within the cluster, between individual houses,
Yes.
that is the choice of the applicant, how close they want those houses to be, whether on the individual lot where they want to be. The setbacks of the underlying zone only apply to the exterior of the cluster development itself.
Okay, so I guess my question is, on this particular site plan, is the lots that are more adjacent to the open space, especially, I don't know if that's north or south or east, I think it's east, is it east?
This will be the southeast
Yeah.
area.
So was there any special consideration given to those setbacks with regard to how close or far away they were to the
Yes.
open space?
Yes, the Integrated Development Ordinance in 52H2A does say that where there is development adjacent to major public open space, there shall be a landscape buffer with a minimum width of 20 feet adjacent to the major public open space. That's one of the two options that the open space superintendent can impose on a development next to open space. The other option is to have a single loaded street to act as that buffer. In this case, the open space superintendent did not want to have a single loaded street along the open space buffer, or along the major public open space rather, because they were concerned about unauthorized access from that single loaded street into the open space. There's also concerns about the stability of the slope along the major public open space. They didn't want a single loaded street that would drain to the open space and cause further erosion to that steep slope going down into the Oxbow. So in this case, they said, we'd rather have that 20-foot landscape buffer adjacent to the major public open space.
And that's really important, because I'm looking at this Exhibit 5, I guess it is, and it talks about the setbacks and conditions of approval from the EPC. And it says a front minimum setback is 20 feet, a side minimum is 10 feet, rear minimum is 25 feet. Is that correct?
Yes, for the RA zone, yes.
Yes. And that relates back to the site plan that we were just discussing, right?
That's correct.
So the setbacks that I'm seeing here in conditions of approval, there's only one set of setbacks that are shown. So there's nothing that calls out the areas that are related to, that are adjacent to the open space areas. They're all the same. The setbacks are all the same for the entire site plan, is that right? And that's what my question really is. Does the site plan, do these standards, are they shown on the site plan?
And you're talking about the condition number 5 setbacks? Because they are a condition of approval, they were not on the site
They were
plan
not
that
on
the
the
EPC
site plan.
reviewed.
Okay.
But in order for them to get that approval, they're going to have to show those setbacks
Right, but they're
on the site
not
plan.
specifically on the site plan, correct?
Right, the one that was
Okay.
submitted.
Thank you, you've answered my,
Counselor Davis, then Counselor Benton.
Thank you, Madam President. I just want to ask if you can help me clarify. Can you show, maybe on the site plan, I know it's kind of hard to do on this map, but where is the distinction the planning department sees between the two clusters? There are different maps.
Okay, Madam President, Councilor Davis.
Thank you, Mr.
This,
Treasurer.
illustration here that the applicant provided shows that cluster A is the orange portion, cluster B is the yellow portion. The cluster A open space that goes with the orange
Yeah.
is the darker green, and the cluster B open space that goes with cluster B is the lighter green.
Thank you. And just so I can, just because it's a little hard to tell on the TV with the bright lights in our face, but I think I can see this. As I understand it, and Mr. Strozier, help me if I'm wrong here as well, or whoever, the orange, the cluster A lots are on the outside, but the open space that is required for the RA is not adjacent. It is only adjacent to 1.5 lots of the however many lots there are in that cluster. Is that correct?
That is correct.
Okay. Is this consistent with the way we have we developed or gone through any other cluster development decisions through the IDO since it's been implemented that you're aware of?
This is the first cluster development in the IDO, but there were several done in the old zoning code. The cluster development allowance is not something new.
Sure.
It was something that was brought over from the old zoning code, and there were several that were done probably over the past 15, 20 years.
Mr. Kobe, is this consistent with the way in which the city has interpreted the requirements for those additional open space requirements, et cetera, in clusters, that it can be attached or adjacent to a very small percentage of the number of lots in the development?
I believe it's consistent because the only requirement is that the open space touch the clustered home area. And different cluster developments have different shapes, different orientations, different sizes, and different relations to major public open space. Some of the cluster developments were adjacent to major public open space,
Okay.
and some have not.
Sure. Thank you. I'm sorry, I didn't mean to cut you off, though. I appreciate that. I'm just trying to clarify for my own reference. Can you, Mr. Kobe, just clarify for me and sort of how the planning department is interpreting this? I'm referencing page 136 in the IDO. It's 4-3 B2C. It was one of those exhibits that was provided by the appellant earlier, for the record. I believe it's page 3 of the appellant's copy, if that's easier, but.
Yes, I'm there.
4.3 B2C, what I'm reading there is it says the number of dwelling units is determined by dividing the site singular area by a minimum lot size allowed all the way to the end shall not exceed 50. Am I interpreting that right, that the site there is viewed singularly, as in considering the entire site?
In this case, the site area is talking about the cluster itself. So you take the area proposed for the cluster development and you divide that site by the minimum lot size for the underlying zone, and that tells you what your maximum number of dwelling units could be.
Right.
But it can be no more than 50 per cluster.
And then all the way down at 43B2E, I'm reading that the cluster development singular shall be designated on a site plan singular. And so I'm trying to find how, let me make my, where I'm coming from and help me figure out how the planning department gets there. And we're all lucky that I'm not a lawyer, so help me with this. The IDO is designed in order to be, provide some specificity and sort of ease of understanding for developers and for residents. And so I sort of always try to default to what is the plain English reading of that for somebody like me. And when I see that, I see single cluster development and on a single site plan. Can you walk me through again, just really quickly, how the planning department has interpreted that to allow multiple clusters in a single site plan?
Well, again, we're not trying to read anything in this. It does say the cluster development shall be designated on a site plan and plat. Again, it doesn't say only one cluster development per site plan. That, you know, if the zoning enforcement officer had determined that, we would probably be looking at 2 site plans that are adjacent to each other that would have to have been approved separately at the planning commission level.
Right.
But because the IDO is not explicit limiting one cluster development per site or one cluster development per site plan, the zoning enforcement officer said, yeah, you could have multiple clusters in your development, but each cluster has to demonstrate that they meet every cluster development standard, including the exterior of each cluster has to meet those setbacks, hence the recommended condition number 5 and the planning commission's approval with that condition.
Thanks. And I don't disagree that that was a reasonable interpretation there, but I do want to follow up to that point with the follow-up questions for the developer about why they made the distinction between 1 and 2 different site plans on the site. So thank you very much. Thank you, Madam President.
Thank you, Councillor Benton.
So, Mr. Brito, help me out a little bit with the plan that's on the screen. What side did the developer choose as the front of each of these? The south side?
Well, Madam President, Councilor Benton, we were waiting for that. Because the condition was given to them, the applicant has the choice to figure out which one they want to choose. But we wanted to make it clear that it's up to you, applicant, where you want to choose your front, sides, and rear, but you need to show that before you'll get the final approval and meeting the conditions. So
Okay, so this was going to follow this approval.
that's right. That would still require us to review it and make sure that they're correctly showing the external setbacks for each individual cluster.
Right, and also the setback between clusters.
That's right.
And setbacks, so the setback between clusters, somebody correct me if I'm going afield here of the record and so forth, but the setback between these 2 clusters, I believe, by what I know about this sort of thing, which is something, would probably be a side yard setback to each cluster.
That's a potential. One of the
I mean, follow my rationale here, but unless that division between the two clusters was a street or something like that, that division between clusters would need to be a side yard setback. I don't know, it's, because of the configuration, it's hard to determine how that would be staked out. But here's the big question. These are not public streets, or are they?
They are not proposed to be public
Public
streets.
streets, so therefore, this remains one, say, unsubdivided. So I don't know, you know, once the developer were to give you that decision as to which side they're choosing as their front, rear, and side, there would need to be a proper line in between them to determine what one of those setbacks was. Front, rear, or side, you know, whatever it may be, but that a property line would be required through the middle of this site somewhere.
That's definitely a possibility, and I would defer to the applicant to expound on answering that question.
All right, well, happy to hear from them. I don't know procedurally what's next, but.
Madam President, Council, if you believe hearing from the applicant at this time would be appropriate on that question, you can. The appellant will still have the opportunity to rebut, so it'll be fair.
So we have Counselor Sanchez. Okay.
Thank you, Madam President. Mr. Brito, you made a statement, and I agree with you, that the IDO is not explicit. And that is the problem that I am having with this particular case. I don't think there's total clarity in what is being done. And I believe that the hearing officer acted arbitrarily with the information that he had in the IDO. And that concerns me because he didn't have, I mean, when we put the IDO together and under dwelling cluster developments, should we have made that plural, and it should have been developments and not development?
Madam
That
President,
would be in section 4-2, allowable uses?
Madam President, Councilor Sanchez, I believe that the reason that it was kept singular was to have consistency in that table. And it doesn't speak to any limitation on a particular use in the zone it's allowed in, other than setbacks, provision of parking, landscaping, usable open space, et cetera. And those kind of specific limitations or allowances are usually part of the use-specific standards that are also listed in that table in that last column. And that's probably the more appropriate location to put those very specific allowances or limitations on numbers in relation to the singular use that's listed in the table.
Thank you.
Counselor Borrego.
Russell, you're doing a great job. I just had one other question with regard to the zone itself. And I guess with regard to section 4-3B2, where it discusses dwelling and cluster development. And if you read into that, the question under number 4-3-B-2-D and number 5 specifically, where it asks about common open space may be dedicated to the city as major public open space if accepted by the Open Space Division of the City Parks and Recreation Department. At what point does that occur, that the City Parks and Recreation Open Space Division actually accepts the open space?
That's usually happens at the plating portion, but in this case, that question was asked early on, and the Open Space Division politely said, no, thank you. We've got everything we need down here, and they were confident that the preservation of the private on-site open space above on the bluff would be enough of a buffer to maintain protection of the city's Oxbow major public open space below.
So what you just said, then technically, they have not accepted that as major public open space at this point?
And I don't believe there's any intention to accepting it or even asking for it, because then it becomes public open space, and the city's on the hook then for maintenance and policing it, et cetera.
So it's not, in general terms, not related to this, they don't accept it until after the development has been signed off by the DRB?
They've already stated on the record that they're not interested in acquiring this
Okay,
property,
so
even if
they're
it's given. And so, the applicant can ask again, but
Okay, thank
I'm
you.
confident they'd get the same answer.
Counselor Harris.
Yes, I'm going to ask Mr. Melendrez a question, and my training's a little bit different, being a lawyer, and this notion of you used a singular noun, I guess it was, and the notion that it wouldn't be a plural and vice versa. And actually, there's a statute, and in New Mexico, it's called the statute regarding Uniform Statute Rules Construction Act, and it says that a singular number includes a plural, and a plural number includes a singular. And really, there's all kinds of cases under the statute that when a statute says conviction, it means convictions. When it says offender, it means offenders. When the statute says, for instance, there's a case where there's an owner of property, and it means owners of property. So, is that kind of the understanding, Mr. Melendrez, that statutes generally are read to mean singular, can mean plural, and vice versa?
Madam President, Councilor Harris, that's the general rule, and as you mentioned, with respect to the statutory interpretation statute that guides the courts in interpreting state statutes, our courts have opined, and there's lots of precedent for this, that city ordinances are interpreted the same way as state statutes. So it's very likely that that interpretation of singular and plural would be applied the same way to ordinances. And in the Lujo's analysis, the Lujo, who's also a trained attorney and has been doing this for many years, did not find issue with the fact that a particular word was singular or plural. He read it into the overall intent of the IDO.
Okay. Yeah, and so that's kind of I think people are making an issue out of something where the statutes tend to be they happen to use a singular, but it can be read to be plural and vice versa, and that's kind of the way they tend to be interpreted. And so, and the statute I'm talking about is New Mexico Code 12-2A-5. So I think that's not the issue, to me anyway, is whether or not cluster development means cluster development. So I think it's obvious that it can.
Okay, well, with that, we will move on to rebuttal by the appellant. 2 minutes.
Madam President, councilors, I'll respond first to Mr. Harris's comment about a state statute. Think of what a slippery slope you'd be going down. If you read the IDO, every time something is in the singular, it means the plural and vice versa. There is absolutely no telling where that would lead in interpreting the IDO. Ms. Jacoby said this property, it could have been done in two separate projects, could have been subdivided and split off into 2 projects, and each one could have a cluster development. But that's not what's before you. What's before you is one site plan with 2 cluster developments. She then cited the table of allowable uses in that table. In addition to cluster developments, for example, there's townhouse, singular. But if you go to the townhouse regulations, you'll see it's talking about multiple townhouses. Contrast that with cluster development, singular in the table, and then go to the regs, it's all in the singular. Mr. Strozier said, well, why'd they do, they went from one cluster to many clusters in their first plan after the 1 cluster plan. They had 4 clusters, and then they went to 2. The reason they're doing that is because they lost land at the east end of this property that was declared to be too sensitive to build on. That's why they went to multiple clusters, to get around the 50-lot limitation. In essence, you have the opportunity to just read the ordinance, read the cluster development regulations, and by the express terms, cluster development is in the singular on a project site. Thank you very much.
Thank you. Before we make any motions, we'll move on to AC 19-7, and we have same process, is that A, 8 minutes, presentation from the appellant, Taylor Ranch Neighborhood Association. B, 10 minutes, presentation from the appellee. C, 3 minutes, presentation by or response to questions by city planning staff. And then finally, D, 2 minutes rebuttal by the appellant. So we will get started with the presentation from the appellant.
Turn the,
Okay, and just before we get started, Madam President and Council, we also have exhibits. I'm looking at the staff attorney here to say the exhibits, there's nothing new being presented. Everything that's in the exhibit is already in the record. And I'm happy to have you examine it before you'd like to accept it if you'd like.
Sure. Madam President, the exhibit does have some presentation material relative to what will be spoken about, but the material that is factual appears to be reflected in the record. And again, they should distribute it to the appellees as well.
Okay, if you can go ahead and proceed and make sure that everyone has a copy. Okay,
You ready?
yes, we're ready.
Good evening. Madam President and councilors, my name's Ken Churchill. I'm one of the appellants, and I want to thank you for hearing our appeal. We thank the council for the concerns raised at the last meeting. Those same issues have been raised by the public since September of last year and are in the record. We want landowners' rights to be honored. We want developers to create projects that truly enhance and protect the bosque. But most importantly, we want to protect the future resources of Albuquerque. If it pleases the council, we welcome further discussion on your concerns. However, with today's limited time, we bring before you just two important issues from our appeal. First, the definitions of project site and cluster development in the IDO do not clearly say that this project site plan can be done. And second, this proposed project site plan does not meet the IDO requirements for usable open space. In addition to Mr. Gully's argument, we hope these 2 points will demonstrate that you should reject this project site plan. First, definitions in the IDO must mean what they say, and I'd like to show what I mean. The IDO uses site and project site interchangeably, and it does not separately define site, but it does define project site. Project site is clearly defined and is used 7 times, specifying development standards, residential use regulations, and lot design, layout, and dimensions regarding cluster development. The project site definition contains just 3 sentences. The first one says that it's a collection of lots on a site plan. The second further defines site plan for the project site, and that term refers to the largest geography specified in the earliest request for a decision on the first application that was submitted. The third sentence is just an example of how to apply the first 2 sentences, and it includes that the entirety of the land in the original parcel is the project site. Sentence 3 is an example. It's not a limitation of some sort. A layperson's common sense reading of the first 2 sentences combines them to define project site as the entire acreage in a site plan when that application is first submitted. We see the September 27th of 2018 first application for this project site, and it shows the total area of the site as 22.75 acres. So by definition, this project site is the total parcel area as was first applied for. The project site is also important to cluster development use regulations. Setbacks, as we've heard earlier, apply to the project site as a whole. The number of dwelling units is determined by the site area, but shall not exceed 50. Common open space is a minimum of 30% of the gross area of the project site. This open space, common open space requirement is a requirement. It's not a suggestion. This site plan attempts to crowd 76 clustered dwelling units into an area zoned for quarter-acre lots. This is a violation of the IDO's plain language definition of project site and how it's used regarding cluster dwelling unit limits of 50. The second major point is that there's an error in the open space site allocation for common open space. The amount of common open space required for the cluster development project was stated as 30% minimum. The definition of common open space is important because it's used in the regulations regarding cluster developments. Common open space is defined as the area of undeveloped land within a cluster that's set aside for the use and enjoyment by the owners. In cluster development, private open space may count as usable open space. Usable open space is outdoor space preserved on-site and managed privately. And in that area, it also states that required drainage facilities shall not count toward required usable open space. The IDO disallows the counting of drainage facilities as required usable open space. But this site plan claims a 1996 AMAFCA easement of 0.98 acres as open space. The record shows that this easement is to be deeded to AMAFCA upon acceptance of the site plan and will no longer be owned by the homeowners association, and it cannot be counted as open space. Record page 147 is the site plan graphic. The red highlights I've added here show that the easement on the site plan is indicated, and it's located on the northeast corner of the project site. This enlargement highlights the drainage facility. As a site plan private open space, the site plan claims the drainage facility as part of the common required open space. The AMAFCA easement from more than 20 years ago is specifically disallowed by the IDO and cannot be counted as required open space. It's important to subtract that AMAFCA acreage of 0.98 acres for the drainage facility from the claimed open space in this site plan. The corrected open space subtracts 0.98 acres from the claimed open space of 7.38 acres. The actual open space provided is just 6.4 acres. The project site common space site plan requirement is for 7.29 acres, as stated in the site plan. And since the actual open space provided is only 6.4 acres, the site plan has an open space deficiency of 0.89 acres. In summary, these two site plan errors in applying the IDO definitions are critical as precedents going forward. The first error is a misuse of the project site definition, done to overstate the allowed number of clustered dwelling units. Secondly, the second error is claiming as provided open space an area that's specifically not to be counted as open space in cluster developments. We ask that the EPC approval of this site plan be rejected for cause. We welcome further questions and comments, and we thank you, Madam President and Council, for your careful consideration of our appeal today. Thank you.
Thank you. Next, we have a 10-minute presentation from the appellee.
Go ahead.
Thank you, Madam Vice President, members of the council. The appellants stated that project site and site area are the same thing, that they're used interchangeably in the IDO. That's just a statement. I don't know where that comes from because the definitions in the IDO do not state that. In fact, I would say that if the drafters of the IDO intended to use a defined term, we have a comprehensive definition section in the back, and that's exactly what they would have done. And there was a question earlier from Councilor Sanchez, and I think that the answer to that was a little incomplete and touches on this answer or this question. And so I wanted to clarify that. There actually was a declaratory ruling issued with respect to this project. It wasn't issued with respect to whether or not 2 clusters are allowed on a site. The applicant requested a declaratory ruling after the EPC approval to clarify what is the project site here, because what we were looking at was those setbacks that we had such a discussion about earlier, with the idea of the project site is this entire area of the 22, 23 acres, then the setbacks would run along that perimeter. And so you would not need, was the declaratory ruling requested, you would not need a particular setback requirement in between the 2 clusters. That declaratory ruling was summarily rebuffed by the ZEO. And he said, no, project site means each of those clusters, and so you absolutely do need that setback between the 2 cluster areas. And so I can see where the appellants got confused about the term project site here, but the ZEO was very clear in his analysis about that applying to each cluster. And that's not the defined term used for the 50 acres, which refers to a site area in any case. And so the ZEO said, you know, we're going to consider this as though you could apply it on 2 different site plans, and all those requirements, including the setback in between the 2 clusters, is going to apply. And the ZEO's decision was very internally logical that way, where the position espoused by the appellants, as we've stated, leads to an absurd result where we could come in with the 4 different parcels, plat them separately, get this approved following all of the rules, but because we chose to put it on one site plan so that everything could be considered as a whole, that's going to be grounds to reverse. That doesn't make sense. And so I'm going to have Mr. Strozier talk a little bit more about those, that open space that's provided here and the confusion, I think, that came up about definitions that are being applied, and also the sensitive lands analysis that was discussed earlier by the councilors. Thank you.
Great. Thank you, Jenica. I'm going to start. I want to clarify a couple things related to open space. And this is critical in that, and this is page 479 of the IDO, and it goes on to page 480. But this is where the open space definitions come up. So the very first one under open space definitions is common open space. Once again, if you look at the cluster regulations, it speaks to common open space, once again, a defined term. The defined term for common open space clearly lists as one of the allowable uses, and it makes sense because you're trying to avoid sensitive lands, one of which is drainage facilities and floodways, that drainage facilities are included. If you go on to the next page, there's a definition of usable open space, and that's the one that they have keyed in on. And the important thing is to, and this is one of those things with the IDO, you have to go back and forth between different sections. Then if you look at page 190, which are the development standards, you will see that in the RA zone, so there's a separate section on the table for usable open space. And you look at RA and R1, and it says NA. Usable open space is used specifically for multifamily projects. And so when you get to the multifamily projects on the right side of the table, you will see that it defines usable open space as a requirement per 1 bedroom, per 2 bedroom, per 3 bedroom. It is specifically allocated towards multifamily. Usable open space as a defined term does not apply to the common open space in the regulations in the IDO for this particular project. I want to talk now about the sensitive lands, and we talked a little bit about this before, but I'm going to put this graphic up and kind of go through these. So with regard to IDO Section 5.2, site design and sensitive lands, we spent a lot of time, as I mentioned before, working with staff, working and planning staff, hydrology staff, open space staff on how to best accomplish what the IDO and the comprehensive plan spend a lot of time talking about. And so what we did was we went through, and just real quickly, we provided an analysis that used updated topographic survey data. We went out as a project team and did a detailed site analysis of the property. We reviewed the existing easement documents that were available, aerial photography, the city's GIS system, and we put all that information together, and that became the basis for the sensitive lands analysis. And I'll go through each of those components individually. And I want to mention that one key component of the site plan that's hard to see, it's kind of a minor line that's, and if you've been out to the property and walked it, you'll see it. There's an existing fence. There's an existing pipe and wire mesh fence that basically separates the upper part of the property from the steep slope area and the lower part of the property, which includes the wetland and the area that's part of the San Antonio Oxbow. We specifically identified that on the site plan and the landscape plan as a sensitive land protection area, and identified that no construction activities or access. That's critical. This is not an area of open space where the city wants access. This is very limited access in this area. They do not want people walking down into the bosque in this area. They do not want people going down into the San Antonio Oxbow. So there's no access that's permitted from this property into the adjacent major public open space other than that at the trailhead, which is to the south of this property. I want to run through that analysis of the different components. So one of the things that it talks about in the IDO sensitive lands is, are there large stands of mature trees? Okay, well, basically if you look, the green area down on the east, that's really the canopy of the cottonwoods that are in the bosque. The actual cottonwoods are not on this property. They're off-site. They're in the city major public open space. But you can see we have a huge setback in that area to make sure that development stays as far away, very far away from that edge of the property. There's also a number of trees that exist that were developed as part of the pool house plans. Many of them are not in very good shape. They haven't been irrigated for many years, but there is a stand that's in our kind of main interior open space, and that's this stand of 6 to 7 healthy pinon pines, which we, as part of the conditions of the EPC, we're going to preserve those as part of our site plan moving forward. There is a FEMA designated floodplain that includes 2 parts. One is the San Antonio Arroyo, which actually comes down along our northeastern edge of the property that provides that drains into the bosque and the San Antonio Oxbow. There's also an Amafka water quality pond that's there, and that's critical for a couple of reasons. That was built on an easement. It's included actually on the northern portion is part of the Andalusia Homeowners Association tract, and it's on our property as well. I'm running out of time, so I'm going to go real quickly. The steep slopes, this kind of orange or salmon color is the steep slope. Once again, that steep slope is outside of that fence that's existing, so we won't have any access or any construction activity that's allowed on the outside of that fence. That's designated clearly as a part of the site plan. So I think when we talk about sensitive lands, we took a lot of time and care to figure out what those lands were. We worked very closely with planning staff, hydrology staff, and open space staff to determine. The question was asked in the earlier questions, I think, by Councilor Borrego about the public open space. Early on in the process, we went to open space, we sat down with them and said, look, we know this is sensitive, it's important, do you want it? Do you want us to dedicate it to the city? And they said no. Thank you very much. Happy to answer any questions. Appreciate your time.
Thank you. Next, we have a presentation or response by, to questions by city planning staff. 3 minutes.
Madam President, if it's okay, I'd like to ask Mr. Strozier a follow-up question before we move on to planning, if that's permissible, or I'll come back at the end if you'd prefer.
Yeah, why don't we just come back at the end?
Sure.
That way we can all do all the deliberation discussion at that point. Thanks, Mr. Strozier. So,
Madam President, Councilors, Russell Brito, City Planning Department. There's talk about the on-site open space and whether or not the Open Space Division wanted it. At the time that it was offered, I believe part of their initial declination of that dedication would be because it would put major public open space immediately abutting private homes. That's often an issue because sometimes private homes dump things over the wall, like grass clippings, into the major public open space that aren't compatible with the intent of the major public open space. Those folks that are immediately abutting open space kind of have an advantage for access that others don't have. And it would require city maintenance of the dedicated area because it would be major public open space. There's also the cost of stabilizing the slope that's on the eastern end of this development, and it sits above the Oxbow open space. The cost of stabilizing this slope is the burden of the owner. Right now, the cost of stabilizing that slope is on the applicant. They have to stabilize that so that their dirt doesn't flow into the city's major public open space, especially the sensitive Oxbow Marsh. If it became major public open space, then the city's responsible for stabilizing that slope. And it might be responsible for protecting those private properties above on the bluff as well from sliding into the major public open space because the Rio Grande is a river. It does meander a bit, even though it's pretty controlled. And that east-west meandering does cause some erosion sometimes, as well as rainfall. But of course, there's always the opportunity that these issues could be addressed if the offer was made again. Maybe the city does say, well, if you stabilize the slope, then we'll take it. There's always that possibility, and I believe that the city is open for further discussions about dedication of that property to the city as major public open space. I'll answer any questions if you have them.
Can we just wait for the 2 minutes?
That's fine.
Thank you, Mr. Brito. So 2 minutes for rebuttal by the appellant, if any.
Yes, I do have some. It was mentioned earlier that project site and site are not really interchangeable, but in the definition section, project site is clearly defined. If the two terms were not interchangeable, why isn't site defined in that area of definitions? Also, common open space is required, and it's stated as being usable for the use and enjoyment of the owners. If the Amafka drainage facility is included as open space, how do you enjoy it? How do you use it? You don't send your grandkids out to stamp their feet in the water of a sediment pond that is the drainage area for a regional drainage facility. There's going to be garbage in there. There's going to be refuse. There's going to be litter. It's also, once this is done, that area isn't even going to be owned by the homeowners association. So how can it be claimed as 0.98 acres of allowable common open space? I'm an Iowa farm boy. I don't get it. Okay. Okay. Anything else you think? Okay. I think that's it. Any questions?
No, I do have something.
Oh, you've got something to add?
Yeah.
Okay.
Yeah, Madam President and councilors, I just wanted to address two things. One was earlier the applicant mentioned that this was an area of consistency, especially with setbacks. And I wanted to just show you on page 23 of the handout. This is a graphic showing what the setbacks are of the subdivisions that are south of the property and north of the property, as well as the setbacks of the other subdivisions that are around the wetland. And to remind you that this is a wetland. It is one of the most sensitive areas we have in the entire state. And it is one of the few wetlands that we have in the state of New Mexico. So I think that what they're trying to do here, this area along the edge of the
Thank you.
actual wetland is part of the setback.
Thank you.
So thank you, Madam President.
So with that, I think I will go to Counselor Davis first, and then Counselor Sanchez.
No, I think that was Mr. Strozer's.
Thank you, Madam President. I just wanted to follow up with Mr. Strozer, Mr. Jacoby, really quickly. And while you're coming, I'll sort of set this up. We heard a question earlier and some discussion about as I understand it, the site plan itself was originally submitted as one plan, and after discussion with planning, was sort of resubmitted or amended as two separate cluster developments and sort of adjacent to each other. But I want to ask a little bit, and I heard Mr. Jacoby sort of say, like, we could have submitted this separately and just got them both approved and been in the same place without this. But I think that jumps ahead to an assumption that both would have been approved. I want to ask from the developer's perspective, had they submitted one cluster and had it approved, and then submitted the second cluster independently and had it disapproved, would the developer move forward with just one cluster on this site, or are they interdependent on each other from the developer's perspective in order to make the project itself work?
Okay. I think in order to answer that question, I'm going to back up a little bit to look at this property. So this property, the IDO requires, and the IDO requirements. So there's currently 6 city parcels on this property.
Yeah.
And as parcels, you have a choice as a property owner. You could reconfigure those parcels, a minor subdivision action. You could take the 6 parcels and make them 2, for instance. And you could go from there. The other thing is that the IDO specifically requires that parcels within 330 feet of major public open space are treated differently. Well, one of the ways that they're treated differently is that if that property is over 5 acres in size, of which only one of the parcels on this property was, that you have to go to the EPC. In our initial meetings with the planning staff, we said, that doesn't make any sense to us. And they said, that's fine. You can specifically ask the planning director if you can bring the entire property before the EPC at once. So we asked specifically to be able to take more of the property through the process to the EPC because we felt it was important to consider it as a whole. And the planning director agreed, and he said that. So that sort of a little bit of background.
I appreciate that.
So to your specific question, I think that I don't know that it's presumptuous to think that both sides would have been approved independently, but it would make it very difficult for staff and the planning commission to review it, had we done that. And that's specifically why, in working with the planning department, number one, we wanted to bring it all to the planning commission, even though that wasn't required. And number two, we thought it was appropriate that they see both of those cluster developments. When we finally worked through all these issues, and I think Mr. Brito stated this is the first one that's come through the IDO. So there were questions that we had, and there was a lot of back and forth. And I think ultimately what guided it was the comprehensive plan policies and those sensitive land policies. And so I think that we could have, you can always rearrange the puzzle pieces slightly differently. There's no question about that. I think what we ended up with was a really good assembly of those pieces in a way that specifically addressed the major public open space. So I don't know if that answered your question, but that I think that those same policies would have applied to both halves if they did them separately.
I appreciate that. That does help extremely. That helps me a great deal, Madam President. Just in the interest of expediting here, I don't dispute in the record and in anything here that the appellant did sort of with the guidance of the folks in the planning department as the first sort of cluster development process through the IDO, tried to navigate that in a way that they were advised might be most advisory to help everybody understand the scope of this. I don't discount that. But seeing as we are here now, and there are technically two different clusters,
Right.
is it the developer's position that they would be able to independently develop either one of those at this site if one or the other of those was not approved had they submitted them separately? I'm trying to determine if the projects
Yeah.
together interlinked and required to be as one, or could they be separate?
If I could also answer it maybe from a legal perspective, the applicant is under contract to purchase the entire property from the seller, and so I think only having half of it be developable is problematic for that contract, and so right now it wouldn't work. The parties would have to go back and talk about the implications of that, and sort of what the what other options would be out there. And so it would present some legal problems.
I appreciate that, thanks.
Counselor Sanchez.
This isn't a question for the people that are applying for the change, well, not the change, but basically for the application. My question was back to Mr. Brito in regards to the issue of the city San Antonio Oxbow major public open space. I mean, that property is adjacent, isn't it, to the development that we are looking at? I know this is not really the case yet because this issue has not been resolved, and they cannot give open space when we've not voted on this particular case. But I don't know why the city wouldn't say no to the San Antonio Oxbow major public open space being the city's when the property adjacent would be basically benefiting the public. As you stated, it's public open space that belongs to the public, and the neighbors and the members of this community have the right to go to that public open space. Isn't that correct?
Madam President and Councilor Sanchez, as was stated correctly by the applicants, access is limited. You can only enter the Oxbow through the trailhead. You have to stay on the trail because they want to preserve the habitat for the wildlife there. It's very sensitive. We don't have too many marshes here in the desert. So a lot of the access is visual access, where you can see it, but you can't go into it. And you can get on the trail to get a little closer, but you can't step into it. Again, if the discussion came up again about dedication of the open space division might have a change of heart, you know, if they could be guaranteed that the slope was stabilized to their satisfaction, so that the city would have minimal responsibility to stabilize that eroding, unstable slope right now. But I think, again, the reason they first said no thank you is all of these issues combined pointed to, is it worth it? But in the future, if there's some agreement, it's possible the Open Space Division could change their mind.
Thank you.
Counselor Borrego.
So, Russell, in terms of where the open space is located, was there a drainage easement provided to AMAFCA for that open space? I mean, from the developer? In this
President,
development?
Councilor Borrego, there is an existing easement on the site.
Is it a drainage easement?
Yes, for the Amafka Pond, and that's pre-existing. It's been there for a while.
Okay.
But it's still owned by the applicant, but it's encumbered by that easement for Amafka's benefit.
Okay, with the development of this particular site plan, it's possible that the drainage could change, correct? Once it's developed.
It's possible. My recollection from testimony that's in the record from the city hydrologist is that he would want the drainage to go northward to that pond so that it would not go east towards the major public open space.
But it's also possible that AMAFCA may not accept that. They may need more or less depending on the flow after it's developed.
Yes, that's a possibility because there's also on-site ponding in the common open space that's possible, but they would be adding some impervious surface in terms of roads and houses, patios. All that technical review still needs to occur at the development review
So the
board.
existing drainage easement that's already dedicated may not work particularly for this, I mean, after it's developed is what I'm getting at. And AMAFCA may have some issues in terms of how the drainage flows through there.
That's a possibility, yes.
Thank you.
Counselor Benton.
So, Mr. Brito, you mentioned this is the first cluster development site plan to come in under the IDO. Prior to the IDO, was there any similar site of this size? Was it even allowed to have this large of a cluster development?
Madam President, Councilor Benton, prior to this, in the old zoning code, I don't recall anything this large coming in. If memory serves me, the largest cluster development I can recall was in the Montecito area, further west from this site, and that maybe had close to 50 units. They did create a cluster development because there were some very steep slopes involved with some canyons and little escarpments that were up there related to the lava flows. And so they were able to cluster the houses on the developable portions, create the common open space, and then the open space division accepted the dedication of that open space.
So that also was adjacent to city open space, public open space?
Yes.
Okay. And looking at the appellant's handout, which is a copy of Part 1416-4 use regulations, 43B2D, it states the cluster development project shall include common open space set aside for agriculture, landscaping, on-site ponding, outdoor recreation, or any combination of those, and for the use and enjoyment of the residents. So any open space that we're counting should be for the use and enjoyment of the residents.
Yes, that's correct.
No matter what of many of those features, those were the ors, and then the and was for the use and enjoyment of the residents.
Yeah, and just like major public open space, common open space could be used for passive or active recreation.
Yeah, as you were
for
saying, there could be views, but
visual
not-
relief.
That's a type of enjoyment, and,
Correct.
all right. And I guess I just want to get back, I'll ask you, and then is it appropriate for me then to ask Mr. Strozier to describe this, how they anticipated that this condition 5 would have been met? Any issue with that, of me asking?
I apologize, Madam President and Councilor Benton. I'm trying to do about 3 things at once. Could you
Okay, I'm
please repeat
sorry.
that?
So the question is, procedurally, I wanted to ask Mr. Brito about how this condition 5 was intended to be met, as they understand it within the case.
Madam President, Councilor Benton, I think that's appropriate, given that the condition is clearly in the record and you're asking for an interpretation of
Yeah,
how that will play out.
I mean, there was a lot of discussion right at the end of, in the record about condition 5. So going back to that site plan, I guess we could, sorry to belabor, but put that up again. Is that the one with the two-toned red color? Let's see. Right, okay, good. So, yeah, I would just ask Mr. Brito, based on that condition that was included by the EPC, how would that setback between the two clusters have been measured on this site plan?
That's a great question. And you noted before that the internal streets are private. It's a proposed gated community, so these would be private streets not maintained by the city, sole responsibility to homeowners associations. The internal streets themselves could count as setback and separations between clusters. Again, we're waiting for the applicant's response to the EPC's condition, and we want to see, we're interested to see how it will be met as well.
And that would have been, where would that have occurred? Just in staff meetings or at the DRB or where?
The EPC's conditions of approval require that the applicant meet with the staff planner and go through and demonstrate how each condition is met.
Right.
That's something that we've done for decades.
Right.
And then they can submit to the DRB for the final review for the technical issues and to look at those conditions. The staff planner will provide input to the Development Review Board about non-technical conditions and whether they are met or not. But the technical conditions that might be related to drainage or access,
Sure.
we leave that to the folks on the DRB with the PE behind their name.
Definitely. So DRB doesn't have that much interest in this, I'm just going to call it a theoretical line that was described in condition 5. There's a line there somewhere. I keep getting back to that. And the question is that a property line? Is that a theoretical line down the middle, sort of the way we do in the building code? And so that would have been determined more at a staff level, or would be determined if this goes through at the staff level. Then the DRB takes care of the technical stuff.
And there will need to be a property line. That's where a setback is measured from. So, they might delineate one side of the
Right.
private street or the other as the property line, and then the measurement of the setback would be from that.
And then if I could ask Mr. Strozier and Mr. Kobe, whoever, so in reading the record, Mr. Strozier, there was some discussion of
Right.
condition 5 at the end of the record, at the end of the meeting. You went back and forth a couple of times with the chairperson and basically accepted that condition, as I read the record. But this is something that came along late in the game to you as the developer's representative, was it not?
Well, Madam President, Councilor Benton, so we had been in discussions about this issue, and it was, I have to say that it for for me, it was one of the most perplexing as to how you actually apply it on the ground. And I think, and we had an interpretation that it should be applied to the perimeter of the entire property.
Right.
And the EPC disagreed with that interpretation, and staff also disagreed, and that's where condition 5 came into play. And so what we started to do after the EPC was actually sit down and go through, okay, what does that mean? And we figured out that we could, you know, basically increase the setbacks on this edge in order to meet the rear yard setback of the RA zone. Minor shifts. One of the things that the EPC said was that if in order to address that, it resulted in a major change to the site plan, that we would have to come back.
Right.
We've gone through and analyzed it. We think it's a very minor change. It shifts some lots around a little bit. It increases the size of some of the lots on the eastern edge, for instance. But we feel comfortable that we can meet that condition. Once again, we never got to the point, because the appeal was filed, that we didn't get back with staff and go through the DRB. I'd also mention, you know, DRB, as you're aware, but I think for all the counselors' sake, the DRB is made up of representatives of transportation, hydrology, and all of them weigh in ultimately on whether or not we've met those conditions imposed by the EPC.
Right. And, I don't know, is this outside the record for me to ask where you saw the front setback line for both of these clusters?
So our interpretation was that we basically concluded that the front setback line was what we proposed to be the southern boundary, that the
public
rear
street
would be the north boundary, if you will, and, you know, the cluster snakes around with those interior streets. So we still had some questions for staff on, and wanted to sit down and work directly with them to interpret how those rules would be applied.
Okay, thank you.
But we felt confident that we could do it.
Okay, thanks.
Okay, thank you. So what we're going to do now is give the appellants an opportunity to rebut some of the discussion that's gone on, because there's been a lot of additional information that's been provided. And then we will close the floor. So we're going to go ahead and 2 minutes if you want to add anything. If not, we're going to close the floor.
Thank you, Madam President, councilors, and thank you for the discussion tonight. I just wanted to say that it's obvious to me that you care deeply about what the public cares about, what developers are trying to do to improve and enhance the city, but our case before you today is to argue that we don't think that this furthers the comp plan. We don't think that it enhances the bosque. We don't think that it improves the bosque or any land that's adjacent to it. The applicant made the argument that they did work very hard. I think it's very obvious that they made every effort to make this better. But just because, but trying to make something better doesn't necessarily mean that it's following the IDO. And I don't think that that means you can read something into the IDO that just isn't there. So I thank you very, very much for all the time you've taken to hear us tonight. And I look forward to your decision. Thank you, Madam President. and
Thank you.
councilors.
Now that we've closed the floor, before I go to Councilor Sanchez, I just kind of want to read for the record. We need now to make on both AC 6 and AC 7, make one of the following motions. Remand to the Environmental Planning Commission, grant the appeal and reverse the decision of the EPC and adopt findings at a subsequent meeting, deny the appeal and uphold the decision of the EPC and adopt findings at a subsequent meeting. And then we would need a vote. So with that, Councilor Sanchez?
Thank you, Madam President. First, I would like to thank this council for allowing a full hearing on this issue tonight. I believe this is a very complex issue, and I think the deliberation tonight basically was why we took so long to deliberate this issue, because of the complexity of this case. And I do not believe that there is total clarity in the integrated development ordinance. I think there are issues that are still outlined, and I believe there's going to be some amendments to the IDO, and I think we're looking at 500 possible amendments to the IDO. And that, I think, is one of the reasons that we're dealing with this case tonight regarding cluster development. And we've not seen a cluster development of this size in the past, and that is very concerning for me. And at this time, I would like to grant the appeal and reverse the decision of the EPC and adopt findings at a subsequent meeting.
There's a motion and a second to grant the appeal and to find findings at the, add findings, adopt findings at this, at a subsequent meeting. All those in favor?
Madam
Yes.
President, before I vote, I'd like to ask a question and make a point. So the question is, if this is accepted, this property applications for development of this property, what would be the implications of going forward?
Madam President, Councilor Benton, so there's a general rule about zoning requests that if you try and get denied, that you have to wait a period of time. That wouldn't apply to a site plan. And so I think that's your question about what would happen if the council were to deny the site plan. You know, the property is zoned. It has zoning to develop residentially, so the property owner has some right to proceed with the development at
All
the
right.
site in some form.
Would the property owner have the right to proceed with a cluster development, or two cluster developments, for instance?
Madam President, Councilor Benton, there's a whole number of outcomes that could result from the motion that's on the floor, including, but not limited to, the developer could appeal this decision of the council to district court.
Sure.
And if successful there, we could result in a remand back to the council or some interpretation of the IDO
Yes.
that is consistent with the developers or the cities. And so that's the next step in that arena. In the event that the developer chose not to pursue an appeal, there would be an opportunity for a reapplication in some form, whether it's a traditional development, you know, that would be permitted under the IDO or a cluster concept that responds to whatever findings the council adopts at its next meeting.
All right. Madam President, if I may, I'm going to oppose the motion because I think this needs to be remanded to the EPC. I think the EPC and the applicant and staff together came up towards the end with this condition 5. I think it's a creative solution, but I don't think it does read this way in the IDO, and I would dispute that the IDO is the problem here. I think the problem here is getting a little bit too creative with the actual words of the IDO, which clearly do say, on any given site, the number shall not exceed 50. So without lacking a property line that was considered by the EPC, I think we went off track here. And versus completely accepting the appeal, I think, you know, this is a right of a developer to build cluster developments, but that they would have to, this would have to be truly true cluster developments on 2 sites. And I'm not trying to go into what the solution is, Councilor Sanchez, but just to explain that would be my reason for voting in opposition, that I think it's more appropriate to be remanded.
So, Counselor Benton, was that can you do that in the form of a motion?
There's a
Because
motion on the floor.
opposing-
Yeah,
yeah.
there is a motion on the
Okay, yeah.
table. I'm just explaining my
Okay.
vote.
Okay. Counselor Jones.
Thank you, and I also believe that this needs to go back to EPC. The reason is, we're trying to solve a question here, an issue here that isn't normally what we solve, nor have all the information on, and I think we're kind of guessing about a few things, or what maybe we like, and I believe the EPC is a very good board that knows how to discuss these things. They know the rules. They're very good at this, and if we simply ask them to take another shot at it, I think both parties will be much more pleased than if we intervene personally. So I also cannot support that motion.
And I actually came in today being ready to just reject the appeal and let it go forward, because I am concerned that as much as the appellants say they want to respect property rights, I don't think they are. I'm very concerned in this city what people see private property that's beautiful, and they want it to be their private open space. And it's not. It's someone's private property that they're entitled to do what they have a constitutional right to do, which is to develop their property. And I think that there's a flavor of that here, and I don't like it. But at the same time, I'm concerned about that the developments, the cluster developments that are connected by the same road in the same area across the street. I think the IDO does allow for cluster developments, even on the same project site, but I think they should really be two clusters, not a cluster that you pick which side of the road is the cluster or not. I think that is a little artificial. So yeah, I would like the EPC to find something and to kind of sort through that and really make it two separate clusters and work through that in a way that that respects the property rights of the developers, and I hope to get this done, and it looks like they have worked very hard. This is a tough process, and I hope they hang in there and get this done.
Counselor Winter.
Thank you, Madam
Counselor
President.
Sanchez.
And this was a tough one to follow, and it was very tough. But I think I'm going to support sending it back to the EPC. In fact, the appellant made a comment. He said, don't read language into the record that is not there. And the applicant also made the same comment. Don't set precedent applying what is not in the IDO. So you have both folks kind of saying the same thing, and we really don't quite understand, I think, or it got moved around something about what the IDO said and what it means, and this hopefully will clarify it.
Counselor Sanchez.
Thank you, Madam President. Based on the discussion here on the dais, I will withdraw my motion and move to remand this back to the Environmental Planning Commission.
Madam President, if I can kind of jump in here and maybe make some suggestions about the direction the council is moving in. So these were pretty in-depth appeals, both of them, as we know, with some relatively new and complex issues. As I mentioned at the last hearing, the LUHO wrote a 35-page recommendation on this, which is the longest I've seen from the LUHO, and did a very thorough job of analyzing everything. The issue that the council has appeared to focus on tonight and has continued to discuss is related to the clustering, and it sounds like that is the primary issue. I would recommend that you consider disposing of the remaining issues in the appeal, and to the extent you're interested in clustering, send it back for them to evaluate the single question of clustering consistent with your discussion tonight and the findings that you'll adopt at a subsequent meeting. And that would narrow the EPC's focus. And if you were to do that, then your motion would essentially be to remand for them to discuss clustering and otherwise adopt the recommendation of the LUHO, accepting page 11, line 211 through page 17, line 359.
Okay, Counselor Borrego.
I did have my hand up, Madam President, and for some reason was disregarded. And Chris, I understand your thoughts. I think it's a very important thought. But there are also some issues with regard to questions on the site plan and issues that were not actually discussed. I mean, actually, they were discussed, but they weren't addressed in your comment just now. And I think the questions that I have in my mind are, the comp plan does not have density requirements. And to me, that is a huge issue, because it, and if I may finish, thank you. The open space calculations, the way that they were interpreted, there are specific easement, there's an existing easement, and the flow for the flood control changes. And I think that, that needs to be weighed in. The cluster development questions, what is a cluster development? The site plan that I looked at tonight didn't show a cluster. I mean, it showed something that seemed pretty ordinary in terms of the subdivision. So I think that by limiting ourselves too much, then we can't answer some of these other questions.
Madam President, Councilor, if I may, the council has discretion to do what it wants on this, or what it, in its best judgment, after hearing the parties tonight, believes is appropriate under the IDO. And to the extent that you have specific issues that you want the EPC to consider, those should be listed in the findings that you'll adopt at a subsequent meeting. However, my suggestion was not related to the concerns that you've raised just now, but there are a number of other issues raised in the appeal that weren't even discussed tonight, and so I'm not sure how the council feels about those. And specifically, the EPC erred in block length questions. If you don't resolve that issue, it'll still remain an issue in appeal. The site plan does not violate areas of consistency. That doesn't seem to have been an issue of the council. That would remain unresolved. The EPC made OMA violations. That would be an issue that would remain unresolved. So my suggestion was that there are a number of issues that you could resolve tonight and narrow your remand to what you really want to hear about, but that's your discretion.
Thank you, Madam President. I don't believe that this came to us, and we agreed to hear it because we wanted to write it ourselves or rewrite it. We have some very well-respected and experienced committees and commissions who do this. They get great advice. We provide legal counsel for them. The appellate has, everybody has legal counsel on this if needed. I think we need to go back through the process, and I respect the idea that we could send it back to EPC and ask them to take the second look at it, most especially the cluster. That seems to be the one that really makes everyone nervous because it's a little different from usual, and see what happens. Worst case, comes back to us again on another appeal, but I think we need to give them the shot at how to do this. Thank you, Madam President.
Councilor Harris, then Councilor Benton.
Yes, and one thing I'm particularly concerned about now is it's 7 after 10. I think we're going to be here till midnight. And so what I'd suggest is that Mr. Melendres comes back with kind of some language on the remand next meeting that says we want the EPC to address this, but the other issues that they're not going to address still are active and live and can be brought back, something like that.
Madam President, Councilor Harris, that's a possibility as well. And so tonight, if you'd like to vote to remand, you'll have the opportunity to adopt specific findings and instructions at your subsequent meeting.
I make that motion.
There's a motion on the floor.
There's a motion on the floor already. Councilor Benton?
Yeah.
So there is a motion on the floor from Councilor Sanchez, just a
Yes.
point of order, which is to remand. The question is, what direction, if any, are we giving to Mr. Melendres right now? I think the one, if I could try to summarize that, it would be that that we agree on the form of the clustering, and the form of division between the clustering is something that is one key issue, and the others, you know, there are other issues that have been discussed, and I think the procedure on that would be, unless anyone wants to articulate beyond what Councilor Borrego just did, what other possible concerns we would have to be addressed in the findings, that would be the key one that I've heard that there seems to be a fairly strong sentiment about.
And I do support that, and I believe that Councilor Harris brought up a very good point to let the, our attorney, Chris Melendres, our analyst, come back with the additional recommendations at the next meeting.
Madam President, Councilor, that's something that we can do within the next 2 weeks before your next meeting, and those findings that will be presented to you will be circulated to the parties in advance, and they'll have the opportunity to submit written comments to you.
So, yeah.
Second the motion.
I just want to add, it just sounds kind of open-ended, right? Because who's going to have the discretion of what issues are going to be, and then once you circulate it, then I'm sure all the parties are going to want to really talk about other issues that they have, because I know that the appellants actually said that they really only had the time to talk about a few issues, and some other ones were important to them. So I think it's really kind of incumbent upon us this evening to really just really quickly outline the ones that we feel are important. And what I'm hearing from Councilor Sanchez is it's about the clustering, and what I'm hearing from Councilor Borrego is that it's about the AMAFCA and the drainage.
Well, the open space
And the open space
calculation.
calculations. So would everybody agree to those items? Okay, so would that be in the form of a motion?
That'd be fine. That is the form of the motion,
So
correct.
I will second that
Okay, so
motion.
there's a motion and a second to remand it back to EPC with the items we just discussed.
Madam President, that's good, and we will get written findings that are explicit in that regard for you to adopt at it's your next meeting.
Okay, perfect. So all those in favor, say yes and raise your hand.
Yes.
Opposed, no. Motion passes. So thank you. So that was actually, okay, so we need to do the same thing for AC 7. Okay, so would you like to form it in the same?
Thank you, Madam President. I move to remand to the Environmental Planning Commission with the recommendations by this council.
Second.
So there's a motion and a second. All those in favor say yes and raise your hand.
Yes.
Yes. Opposed, no. Motion passes. We are now on AC 9, Oso Grande Neighborhood Association appeals the zoning hearing examiner. Mr. Melendez, explain the appeal.
Madam President, just, if you give me just a minute, I'm sort of knee-deep in this other one. Let me get my material out.
Councilor Sanchez.
Thank you, Madam President. I'd like to move to suspend the rules till 11 p.m.
Second. All those in favor say yes. Yes. Opposed, no. Motion passes. So I think there's a couple of people who were thinking earlier that are out.
Madam President, I'm ready to proceed.
Yes, Mr. Melendez.
Madam President, AC 19-9 is an appeal.
If we can have some quiet in here, thank you.
Is a land use appeal that's before you for acceptance or rejection of the recommendation of your land use hearing officer. The issue in this appeal is whether an indoor storage facility should be conditionally permitted at the southeast corner of Osuna Road and Juan Tabo Boulevard. The zoning hearing examiner determined that the use should be approved at this location because it would not present significant material adverse impacts on the surrounding areas. The Oso Grande Neighborhood Association, the OGNA, appealed that decision. The council referred that appeal to its land use hearing officer, who recommends that the appeal be denied, that the ZHE be affirmed, and that the CUP be approved. The subject cited issue here is a 2.37 acre lot. It's zoned MXL, where indoor storage is a conditional use. The ZHE approved a CUP at this site based on 77 individual findings, finding that the proposed use was consistent with the comp plan and the IDO and would not create adverse impacts. However, the appellants argue that the proposed use is generally inconsistent with the area and does not satisfy IDO goals of respecting and enhancing the unique character of neighborhoods and protecting residential quality, and that it will disrupt parks and open space in the area. The LUHO determined, however, that the ZHE should be affirmed because the use meets the criteria of the IDO. The ZHE did not act erroneously to exclude relevant evidence or to permit application changes through the process, and the ZHE adequately considered the impact statement that was submitted by the appellants. You will not hear from the parties tonight. Tonight you'll be considering whether to accept the LUHO recommendation and findings or to the extent you have questions about those findings or need guidance for that decision, I will try to answer your questions the best I can based on the record. In the event that you need additional discussion, you may reject the land use hearing officer's recommendation, in which case we would have a full hearing on this matter at a later time.
Okay, thank you. So are there any questions from the councilors, or are there any motions on the floor? Councilor Benton.
I don't have a question, but if someone else does, that's.
No questions.
All right, I'd like to move to accept the LUHO's recommendations and findings.
There's a motion and a second to accept the recommendations. All those in favor say yes.
Yes.
Opposed, no. Motion passes. Next, DAC 1910, JEG Planning and Zoning Agent for Pamela Willie, appeals the zoning hearing examiner. Mr. Melendez, can you please explain?
Madam President, the issue in this appeal is whether or not a side yard setback variance should be approved, even where the findings from the ZHE indicate that no special circumstances applicable to the property would justify the variance. This matters again before you for acceptance or rejection of the land use hearing officer's recommendation. The land use hearing officer determined that the ZHE decision should be reversed because all requirements of the IDO were not met and the specific findings that are required for a variance were not satisfied. The council may choose tonight to accept or reject that recommendation. In the event you have questions, I'll do my best to answer those from the record. If you need more information, you can have a
Thank you,
subsequent
Mr.
hearing.
Melendez. So if there's no discussion, is there a motion on the floor? There's a motion and a second to accept the findings, recommendations and findings. All those in favor say yes. Opposed, no. Motion passes. It was on is there 9 of us here? 7-1, okay, thank you. Now we are on item 13, approvals. EC 383, report on uses of the 3/8 hold harmless gross receipts tax. I move a receipt be noted. There's a motion and a second. Is there any discussion? No. There's a motion and a second for receipt be noted of EC 383. All those in favor say yes. Yes. Opposed, no. Motion passes. Next, we are on item 14, final actions. Councilor Sanchez, 067.
Thank you, Madam President. This is item F, 067. That is amending Article 6, Section 4, and Article 16, Sections 3, 6, 7, 12, and 20 of the Charter, amending Chapter 2, Article 4, Part 13, ROA 1994, the filing of petitioned ordinance, and amending Chapter 2, Article 4, ROA 1994, to add the limitation on seed money and maintenance of campaigns in off-year ordinances. I move a do pass.
Sir, there's a motion and a second for a due pass. Are there some amendments?
There is, and the staff is now passing out those amendments.
Can you start to explain the amendments, Councilor?
Give me 1 second. I have floor amendment number 1 to O-19-67, and we have the clerk here to basically go over these. Madam Clerk, go ahead and proceed.
So I'll second it right away.
Thank you, Madam President. What this amendment does is it makes a change to the charter that allows for some flexibility in dealing with voter initiatives and will allow us to abide by the Secretary of State's ballot question rule that was recently proposed. So right now, if there's a voter initiative, if council makes any changes to that initiative, both questions would go on the ballot. The question is original form and whatever council does. What this change does is it says that if council makes a substantive change to a voter initiative, then both questions would go on. But if it's not a substantive change, or if the proponents of the voter initiative agree with the substantive change, then just council's version would go on. This allows for much better flexibility for council to work with voter initiatives without sacrificing the protections of voter initiatives that was intended by this section of the charter. This is also going to be important for another amendment you're going to see later on for R-165, where we're making changes to the democracy dollars question. But in order to make those changes, we need to make this change first. And so both of those would have final action on the 19th.
So there's a motion and a second on the floor for floor amendment number 1. Councilor Gibson.
Thank you. Madam Clerk, who determines what a substantive change is? How do we make that determination?
You know, sometimes it will be obvious. Like in the case of the democracy dollars question, the language that is going to be taken out amounts to advisory language. It's language about opting into the local election, which you all have already done. So that would make it an advisory question, which is illegal under state law. So that would not be a substantive change because it's moot, essentially. There might come a time when there is a disagreement about what is or is not a substantive change, and I think that would probably be addressed by the courts in that, if that happened.
Thank you.
Counselor Davis, and then Harris.
And again, thank you, Madam Clerk. Just very quickly, and I think it still goes back to so let's assume the city council makes a change that we believe is technical and the proponents, whomever they may be, believe is substantive. How do we make that decision, or who makes that determination if there's a difference?
I would think that the city would maybe ask the district court for a declaratory judgment on that issue. But I think a lot of the time, I think it's going to be the rare circumstance where it's going to be that subtle that there would be that disagreement. A lot of time it's going to be, there needs to be a period here. There is an extra word here, or this is a moot question.
Thank you, Madam President. I agree with you. I think it's something that we'll deal with when we get into that issue. I want to ask another question really quickly, and it's more technical to you. Just when we mentioned if the question, blah, 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 or the proponents of the measure, who defines the proponents? I seem to recall that it requires 3 voters ultimately. Does that mean that if you are a proponent of a ballot initiative and you represent a cohort of organizations like Democracy Dollars, for example, you need to pick your 3 voters really carefully?
I think so. I think the proponents of the measure are whoever signed that initial declaration of intent to circulate the petition. So yes, I think any coalitions would need to be careful about who they are picking for that to make sure that they're appropriately representing their interests.
Madam President, just to be sure I get this, because again, it goes in the charter, so at that point, it's hard to fix. Technically, 20,000 voters could sign a petition with several pieces of legislation, and even though, but it seems to me that if the proponents change their minds later, for example, and I'm using Democracy Dollars as a good example because it's in front of us, voters said $25, and that's what 20,000 people signed as a $25 certificate, and the city council came behind them and said, no, we want to make it $50, and the 3 people agreed with us. We could make that change even though it was substantively different than what the voters presented to us. Is that a fair assumption? I'm not saying it's wrong. I just want to be clear about plain language how this works.
Yes, no, I think you're absolutely right. As long as the folks who were on the declaration of intent to circulate that petition would agreed with that change, then you would be able to do that.
I think we clearly do need another process by which, or a more clear process by which we resolve some of these issues, and so I support this in terms of if you as the clerk tell us you think this can work, and having run these initiatives, I think this is much better than we do now, so I encourage you and I thank you for your work.
Thank you, Councilor.
Counselor Harris.
Yeah, just one thing that comes to mind, I think with the sick leave ordinance, wasn't there a typo that was going to, if it had passed, immediately result in, well, alleged it was a typo, but the people who didn't like the ordinance was going to use it to say it didn't make any sense. I think something like that.
Madam President, Councilor Harris, I don't recall that on that, but I would not be at all surprised if that was the case. I think stuff like that happens all the time.
Okay, well, with that, there's a motion and a second for floor amendment number 1. All those in favor say yes.
Yes.
Opposed, no. Motion passes. We're back on the bill. Counselor Sanchez.
Urge support.
So there's a motion and a
Madam
second.
President, I'm sorry, because we changed the title of this ordinance, we're going to have to defer it till
I
the
move
next
deferral
meeting.
until the August 19th meeting.
Yes.
There's a motion and a second for a deferral for 067 as amended. All those in favor say till the next meeting?
Yes.
All those in favor say yes.
Yes.
Opposed, no. Motion passes. We are now on G. Counselor Sanchez and Benton, R160.
R160 is adopting a proposition to be submitted to the voters at the next municipal election concerning the renewal of a 0.25% transportation infrastructure gross receipts tax. And we have, I believe, an amendment on this bill.
There's a motion and a second for a due pass of R160, and we have I think, a couple of amendments. So we have floor amendment number 1, Counselor Sanchez and Benton.
Counselor Benton?
Passed out right now.
Yes.
So floor amendment number 1 says on page 2, line 4, strike proposing to and replace with shall the city of Albuquerque. Page 2, line 8, after transit, add question mark. This is the renewal of an existing tax. This will not increase the tax rate. Explanation is this amendment poses the ballot question in the form of a question as required by the SOS Secretary of State ballot question rule and accurately informs the voter of the tax impact of the renewal.
Second?
So there's a motion and a second for floor amendment number 1. All those in favor say,
I'm sorry, Madam President. I just noticed I put in number 1 on that amendment, I put the period inside the quotation mark. If you could just strike that. There should not be a period after Albuquerque for that amendment.
got it? Okay. Man, that was important.
Thank you.
There's one of those.
All those in favor of floor amendment number 1, say yes.
Yes.
Opposed, no. Motion passes. In front of me, I have floor amendment, which would be title number 2. This is on page 2, delete lines 7 and 8, and insert in lieu thereof the following. Proposing to impose a 1/4 of 1% transportation infrastructure gross receipts tax, which shall be dedicated specifically and only for the following uses, not less than 25% for road rehabilitation. Is this correct? Not more than 20% for road deficiencies, 12% for road maintenance, 4% for trails and bikeways, 1% for ADA Act improvements, and 38% for transit. So this is all the standard language that's already in there, correct? I'm just changing one thing. It was,
Yes, or Madam Chair, yeah, there's one correction in the amendment. It should say delete lines 4 through 8, instead of 7 and 8, excuse me.
And Madam President, I just want to note that your amendment would add language to the question as it stands right now. The question reads, shall blah, 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 not less than 57% for road infrastructure improvements, 5% for trails and bikeways, and 30% for transit, is how it reads right now.
okay. That's not necessarily what I'm reading, and I don't see blah, blah, blah in there. No, just joking. So it was just my understanding that I was just doing one minor tweak, and that was to reduce trails and bikeways by 1% and to add that to ADA Act improvements.
Madam
that
President, no, as the bill is written currently, 57% for road infrastructure covers all of the road type projects. So ADA would be contained within that bucket,
Right.
as it were. Your amendment is actually parsing out the road infrastructure to road rehab, road deficiency, and road maintenance. So if you're only intending
My
the
only
ADA
intention is to, so if we can read it
Okay.
into the record that way.
Yeah, so, all right, then the amendment would read as follows. On page 2, on page 2, page 2, line 7, strike the amount 57% and replace it with 56%. And then on page 2, after line 8, insert the following, comma, and 2% for Americans with
1%.
Disability Act.
1%.
1%, sorry,
Okay.
1%.
Is that good? Everybody's got that? Yeah, Ken?
I'm
Counselor
basically,
Sanchez?
Ms. Yara, I believe that we are going from 57 to 58%. If incorporated into the road deficiencies, the ADA issues, or is that going to be a separate issue altogether? I mean, then we'd have to increase by 1%, because I think we were looking at basically taking 1% away from trails and bikeways. I move to table this issue, and you can work
Okay.
on,
And I have a comment before we do
Councilor
is,
Harris.
and I also want the staff to address if any of this is necessary, because should we really be putting this in a ballot question if we can enact legislation that breaks it out later? So let's just do I mean, why have people vote on 1% versus 2%? I mean, why don't we decide that as a council later and just keep it at the 57%? I don't even know where this amendment came from.
Well, actually, the reason that I want it in there, well, it's important to me, but that we don't have that language already in there. So this just gives us an opportunity to have the 1% dedicated for that so that the taxpayers know that they're voting for ADA improvements in our community. And then later on, when we go to dole out the buckets, we would actually have that included already.
Madam
Because
President,
I don't think we can add the ADA later.
I have a suggestion, if we could just add language after the road infrastructure improvements to say, to include Americans with Disabilities Act's improvements.
Okay, that's perfect.
That's better, okay.
That's perfect.
Okay, so that would be on page 2, line 7 at the end. We would insert a comma with that language I just read.
Okay, there was a motion to table, so do you take that motion off?
I take the motion off the
Okay.
floor.
Okay. So.
I can get clarified.
You-
motion that we accept what Ms. Yara just said.
Second the motion. So, okay, so there's a motion and a second for that language
number
for floor amendment number 2. So all those in favor say yes?
Yes.
Opposed, no. Motion passes. So then we are back on the bill. Counselor Sanchez and Benton.
Urge your support?
So there's a motion and a second for R-160 as amended. All those in favor say yes. Opposed, no. Motion passes. Counselor Sanchez, 164.
Thank you, Madam President. This is R-164. That is concerning a bond election to be held in the city of Albuquerque at the next regular local election on November the 5th of 2019, submitting to a vote to the qualified electors at such regular local elections certain questions for authorizing the issuance of general obligation bonds in varying principal amounts and for specified public purposes, and providing the form of a bond question and the designation clause for such questions on the ballot. I move a due pass.
There's a motion and a second for a due pass of R-164,
passing out
and there's
some
some
amendments.
amendments.
Councilor Davis?
Thank you, Madam President. Move floor amendment number 1 to R-164.
Second.
So there's a motion and a second for floor amendment number 1. Counselor Davis, you're going to read them out? Oh, sorry. Counselor Jones.
I'd be happy to if we needed to, but essentially all we're doing here is, Madam President, if we need to read it, I can, but essentially all this does is it adds the line, "This will not increase the tax rate," to the end of each of the bond questions. And on page 3, line 17, after the term center, which deals with the sections on community center bonds, it inserts the language "the homeless" that clarifies that homeless centers or homeless, the funds can be used to aid the homeless in those services.
So there's a motion and a second for floor amendment number 1. All those in favor?
Counselor Jones.
Oh, Counselor Jones, sorry.
Thank you, Madam President. I just want to point out that the legislation that was sent to the administration had this worded all a little differently to include a separate item so the voters would know what one of the issues was, and that was a homeless shelter service treatment center. The beginning of that, and I think that's very important that the voters know that that's a part of this, because it's a very important part of what the city and the administration is trying to do to help the people and to solve some problems. When it's all clumped in like this, not only do we not know that there's something really good in there that we should be voting on, but we also don't know if the money's really going to be used for that, because it isn't spelled out specifically. I will support this because we need to do these things, but it is disturbing that something that the council sent to the administration, pointing out a specific issue that we were asked to support isn't pointed out that way. So that is a concern. Not going to stop this, I'm sure, but it is a concern. And then I have one more question, if I may, Madam
Sure.
President. So can you tell me, please, what is our current outstanding GEO bond debt? I know.
Madam President, Counselor Jones.
Thank
Hold
you,
on just
Madam.
one second. We're coming into
Thank you, Ms. Nair.
the present moment here.
Okay, so I should have asked ahead of time. I apologize.
No worries.
Madam President and Councillor Jones, I don't have the exact number, but I think it's about $350 million.
How much again, sorry? 350?
350, yeah.
350 million? And what is our maximum allowable?
It
that we can-
changes every 2 years. I think the next cycle would be about 160.
Okay. Do you have a range on interest rates that we're paying? I know it varies.
The last one which we sold in April, I think we paid the lowest interest rate. It's about 2.73.
Thank you. I thought I remembered that. So would you say, as our financial expert, that this is a comfortable situation for the city?
Yes, I think so. Absolutely, yeah.
Thank you.
Yeah, thank you.
Counselor Gibson.
Thank you. Just a quick question. Do we have a definition for what this $14 million is going to go for? Do we have, is there anything that I can read or look at or?
Council President Pena, Councilor Gibson, yes, we have a number of documents as well as some drawings. We're going to start rolling, our first planned public presentation of those was at the ABCGC meeting, where we tend to bring these things first, as they like to sort of have the initial review on things that are related to behavioral health. But we'd be happy to share those with you in advance. And then after it goes through the ABCGC process, we're happy to present that here.
Okay, so is going to ABCGC in the next meeting or soon? Okay, thank you. I'd appreciate that. Thank you.
Thank you. So there's a motion and a second on the floor for floor amendment number 1 to R-164. All those in favor say yes. Yes. Opposed, no. Motion passes. Now we're back on the bill, R-164. Counselor Sanchez. So there's a motion and a second for a due pass of R-164 as amended. All those in favor say yes. Yes. Opposed, no. Motion passes. Counselor Sanchez, R-165.
Thank you once again, Madam President. R-165 is adopting propositions to be submitted to the voters at the next local election to be held in the city of Albuquerque concerning questions amending Article 2, Sections 2 and 3, Article 4, Section 4, Article 5, Section 2, and Article 16, Sections 3, 4, 6, 7, 8, 10, 12, 15, and 21 of the Albuquerque City Charter, and adding Sections 22 to Article 16 of Charter, providing the form of the question and the designation clause for such questions on the ballot. I move a due pass, and again, we have some additional amendments.
So there's a motion and a second on the floor for a due pass of R-165, and we have a couple of amendments. Floor amendment number 1, Counselor Sanchez.
I guess I'd like to move or amendment number 1 to R-19-165, and I will allow the clerk to proceed.
Thank you, Madam President, councilors. What this first amendment does is it cleans up the summary language for both the city's public financing question and the democracy dollars question. Just use it for the city's question. It just simplifies the language, tries to make it more understandable. For democracy dollars, it cleans it up, but importantly, what it takes out is the language in both the summary and the full text about opting into the local election, because council has already done that.
Okay. Well, there's a motion and a second for floor amendment number 1. All those in favor say yes.
Yes.
Opposed, no. Motion passes. Back on the bill as as amended, R-165. Counselor Sanchez.
Urge to support as amended.
There's a motion
Madam
and a second
President?
for due pass of R-165.
Madam President, sorry.
Oh,
This
yes.
is another one where we have to have it deferred to the next meeting,
Excuse me?
please. Sorry about that.
Then I move deferral until the next council meeting.
There's a motion and a second for deferral of R-165 as amended. All those in favor say yes.
Yes.
Opposed, no. Motion passes. Counselor Sanchez, R-166.
Thank you, Madam President. This is R-166. That is concerning the local elections to be held in the city of Albuquerque on November the 5th of 2019. I move a due pass.
There's a motion and a second for a due pass of R-166, and we have some amendments coming up.
Madam President, may I make a
Counselor
motion to
Jones.
suspend the rules to extend the meeting until 11 o'clock?
We have?
We have.
Oh,
You wanna
I
extend
thought
it
we
till
went to
11:30?
I thought you went to 10:45. I apologize. Thank you. Probably. Sorry.
So now we have floor amendment number 1, Counselor Sanchez.
Basically, this is floor amendment number 1 to R-19-166. And this amendment reflects changes to voter registration and absentee ballot deadlines in state law. Do you want to elaborate, Madam Clerk?
You pretty much said it, Counselor. Basically, I had some old outdated language in there, and so we've just switched that to say as authorized by law.
Thank you. So there's a
Madam
motion.
President, Madam President.
Counselor
I
Jones?
believe there's a typo in the line, the first line of the amendment, and it says, page 2, line 12, strike not later than 5 PM on Tuesday, October 8th, 201. I would assume you would want a 19 on that.
Madam President, Counselor Jones, that typo was in the bill. So we are taking out the typo and that outdated language.
Oh, we were reading,
We're
sorry.
actually
I had a
correcting
that.
consultant on that question. I had a consultant on that question. We both got it wrong, so thank you.
So there's a motion and a second for floor amendment number 1. All those in favor say yes.
Yes.
Opposed, no. Motion passes. We're back on the bill, R-166. Counselor Sanchez.
Urge to support as amended.
All those in favor, as with R-166 as amended, say yes.
Yes.
Opposed, no. Motion passes. We are now on Counselor Benton, P2.
Thank you, Madam President. I move deferral of P2 until August 19th.
Second.
Sorry, Madam President, if I may.
Yes.
If this is deferred until the 19th, and the amendment that was going to be proposed for it is not
Oh.
proposed tonight, you will not be able to get this
Oh,
on the
that's right.
ballot if it were to
Okay.
pass.
Withdraw the motion,
Second.
Madam President. We will go ahead and move I'll move the due pass,
There's a motion and a second for a due pass of P2.
and then I'll move these amendments, and then we'll move deferral.
Floor amendment number 1, Counselor Benton.
So, floor amendment number 1, on page 2, strikes a line 11 through 32 and replace with proposition with the number to be filled in by the city clerk, proposing to increase the number of city council districts. Shall the city of Albuquerque increase the number of city council districts from 9 to 11? This will not increase the tax rate. And the explanation is these amendments phrase the question in the form as required by the Secretary of State and inform the voters of the tax impact of the change. Move floor amendment number 1.
There's a motion and a second for floor amendment number 1. All those in favor say yes and raise your hand. Oh,
I'm sorry
Again.
again, Madam President, to
Again.
keep interrupting. I just want to make sure that it's clear because we're doing something a little different in this amendment than in the other ones. We did not remove the full text, which is required by the Secretary of State's rule. This one does remove the full text, so I just want to make sure council was aware of that before voting on this amendment.
so is council aware of that? Gibson?
What does that mean?
Well, only that if there was a policy reason not to remove the full text, for example, on R-165, it might be inconsistent that you were removing the full text on this question. I can go into the full text issue briefly if you like. I just wanted to make sure that what was going on here was clear. I can also very quickly redraft this amendment to not remove the full text if that was council's desire.
Madam President,
Counselor Beck.
so just that, Madam Clerk, isn't this a very short text anyway?
The full text of it would not appear as a summary would, as envisioned, I believe, by the Secretary of State. So while it doesn't make very many changes to the text, it's still a good half a page, as opposed to, a short, concise paragraph.
Counselor Davis.
At the interest, I'm against our better interest of prolonging this, why did it take a half page to strike 9 and insert 11?
Madam President, Councilor Davis, I did not draft this bill, so I can't answer that.
I don't mean that in a way, I just mean like practically, they both do the same thing, right? When I'm taking anything else out, it didn't increase funding, it didn't change any numbers, it just did that piece. And so it would be, in my opinion, at the sponsor's discretion of how he would like the measure to appear on the ballot. Is that correct? That's all I want to get at, like, that's all we're doing.
And Madam President, Councilor Davis, yes, I think it's just long because it had to change it in 3 different places.
Great.
So but it's at the councilor's discretion here. I do want to let you know the Secretary of State is not going to let full text on the ballot regardless of what is sent up by council.
I would defer to the sponsor then, thank you.
Counselor Jones.
Thank you, and this doesn't have anything to do with the technical part, but I want to make sure that people understand. This says that this, if passed, will not increase the tax rate. I think that's probably valid, but we also need to know that it will increase the cost of running the city council. I mean, it's kind of misleading, the way that's put down there.
Madam President, Councilor Jones, I can't speak to those costs. I think it is accurate to say that it won't increase the tax rate. I don't know, because the individual tax rate that voters pay, that won't be increased as a result of this change.
I agree with that 100%, but I think it's a bit misleading. I understand why we've put that there, but it will increase the cost of running the city council by quite a bit, and that amount has not come before us yet, so we don't really know what it is, but that's not your problem, but thank you.
So I will stand by the amendment, and let's vote on it.
Counselor Borrego.
Regarding this bill in general, I'm going to vote no on both the floor amendments and the bill itself, because I have a fundamental issue with we're already in a political sort of campaign season, and I think changing the rules just by, and no offense, counselors, but fundamentally, counselors who are running for offices have initiated this, and I don't believe that it's a good idea at this point. So I'm going to vote no on the amendments and on the bill.
Okay, Counselor Gibson and then Counselor Harris, but then we have public comment. We have 3 people signed up to speak, so.
So this idea has been around before. I think the sponsors talked about this before. I think this is really a good time for voters to consider this. And I'm not talking about the merit of the bill itself. I just think that it's something that, this is the time that voters should be looking at this, since we're coming up on the census and redistricting after that, rather than waiting until after the fact. So that's why I have just a totally different perspective
And
than you do,
Counselor,
and that's what it is. That's all. Thank you.
Counselor Harris.
Yes, the last time the deferral passed by a 5-4 vote, and it needs 6 votes to get on the ballot. I just don't think this bill has them, and I'm just going to vote against everything, including the deferral, and try to kill it tonight.
So we will go to public comment. We have Christy Lee Howd, and then followed by Richard Martinez, followed by Steve Cabillas. Vitas?
Good evening, Council President and councilors. My name is Christy Howd. I live at 617 Edith Northeast, number 8, in Albuquerque in District 2, and I'm a member of the Board of Directors of the Citizens Information Committee of Martineztown. And on behalf of the Citizens Information Committee of Martineztown Board of Directors, we are the duly recognized Neighborhood Association of South Martineztown. We offer the following public comments in support of Councilor Benton's proposition that increasing city council districts from 9 to 11, that it be submitted to voters in the November municipal election. This proposition provides an opportunity to address the need for fair representation in our district, District 2. Our district contains most of the city's pocket of poverty neighborhoods. It's downtown, it's Old Town, and the historically rural North Valley, including the jewel of Albuquerque, South Martineztown. District 2 also has the bulk of the city's oldest infrastructure, as well as the greatest storm drainage needs. Increasing the number of city council districts provides an opportunity to address concerns that residents express about the equity of city services in some of the unique minority and marginalized neighborhoods within the oldest and most fragile infrastructure during the redistricting process that will follow the 2020 census. We have an opportunity to fix the dilution of voting strength, particularly among minorities, allowing fairer representation, resident representation of the city council by asking voters to support increasing the number of city council districts from 9 to 11. Thank you for considering this and supporting this important proposition.
Councilor Sanchez.
Thank you. I have one comment and no question, and basically this is not going to guarantee you that you are going to get an additional city councilor for that district. It's based on population, and that's once the census is completed.
Thank you.
Mr. Martinez?
Good evening, everybody. Thanks for the opportunity to speak. I'll keep it shorter. It's almost 11 o'clock. I'd just like to say again that my name is Richard Martinez. I'm from the South Martineztown area as well, longtime resident there, as well as on the board of directors for the Citizens Information Committee of Martineztown. And I'd just like to offer my support as well as the group's support for Councilor Benton's proposal to add, 2 additional council members. I think as well that that provides better representation for the city as a whole. And basically that's all I'd like to say. Thank you very much for your consideration in this matter.
Thank you. Steve?
Madam President, before we proceed, I'd like to move to extend the rules until 11:30 p.m., not a.m.
All those in favor say yes.
Yes.
Opposed, no. Motion passes. Welcome.
Yeah, clock there. Thanks. Steve Caviedes, 837 Palidoro Northwest. I live in City Council District 2. I'm very much in support of this offering. In a city our size, we have way too many people to represent in one district. And I can tell you for a fact that even when this city was smaller, some 15 years ago, when an aspiring man wanted to run for, take on an incumbent, and worked morning, noon, and night, hitting their doors. So much so that I was impressed. I've almost never seen any other candidate do that. They could not walk their entire district. And that was with a targeted walk list. There was no way for a candidate to personally talk to the people he needed to talk to. And that's so desperately needed in our lower level city council politics. And our city's only gotten bigger. So I don't even know if this will help Democrats, Republicans, minorities, non-minorities, whatever. The math says that if you want to have contact with your people about your sidewalks, the sewage, the barking dog, the development right over there by the wetlands or whatever, and have more intimate contact, you've got to have more representation on the city council. Voting for this is voting for personal public contact and getting real and local with your citizens. Not voting for this is voting for big money to keep controlling the whole process. Thank you.
So that was the last speaker, so Councillor Benton.
Thank you, Madam President. And I appreciate the speakers sticking around with us this evening. And I want to reiterate, yeah, this may or may not help what happened to us in redistricting back 9 years ago, whatever it was now. But it also needs to be made clear, this is just putting it before the voters. So whether any of us like this idea or not, I mean, I think some of us do, some don't. Why not have that discussion with the voters and let this get out there? I was remiss, and I apologize, Councilor Jones, because I know that we did a fiscal impact analysis when we looked at 13 council districts back when we were looking at redistricting previous, so we can get those figures. But I can tell you the cost of running the city council in this situation is well under $600,000 most likely, if I remember correctly, unless Ms. Yara helped me out and looked it up.
Yep, Madam President, Councillor Benton, we actually updated that fiscal impact analysis that should be in your iPads for the 11 district variation.
So it is relatively small figure, but I think the important point is, should we have this discussion, and should the voters of Albuquerque consider this? And I do really like the point made by the last speaker about the need to walk doors and to have that kind of direct communication with your constituents. We are different from a U.S. Senate district. We are different from a state house Senate district. That we are we're here pretty much 365 days a year, taking questions and concerns and trying to help people navigate through city government on the most basic issues they deal with on a daily basis. And I think, you know, we have tales of woe from our district, and most of us who are from District 2 understand those tales of woe. This may or may not fix them. This would put the redistricting process through the same process that we already have, or if we chose to improve that process for recommendation of redistricting when the time comes. We still have a little bit of time left to do that. However, it is timely, and this would be about. And I'm not trying to make a close for the bill, because I do intend to defer this, but just wanted to make that point that this is about letting the people decide. So. Let's see, did we vote on?
No, Councillor Benton. So
we
we're
vote on
actually on the floor amendment.
Yes.
So all those in favor of floor amendment number 1 to P2, raise your hand and say yes.
Yes.
All those opposed, no? No. Did you get the number? Fails. So now we are back on the bill, P2. Councillor Benton, to close. Well, not to close, but I guess you're going to defer.
So I guess we should ask the staff, I mean, we do have a second amendment, but does that effectively, this is an issue with the Secretary of State's ballot question rule and so forth, is that still an issue, or should we?
Madam President, Councillor Benton, from what Ms. Duhick told me, likely the Secretary of State would send that back to her to redraft in a summary form if this didn't pass.
Madam President, Councillor Benton, yes, that is likely what would occur. So I would just redraft it probably to reflect this amendment.
I'm sorry, redraft it.
I would, if this was to go to the Secretary of State, she would most likely send it back to me to redraft.
At which point we could not have it on the ballot because of timing.
I'm sorry, what was that?
At which point we could not have this on the ballot this year because of timing.
If If this bill were to pass at the August 19th meeting,
Yeah.
then it would be in time to have it on the ballot, but it would be sent back to me to redraft the question, and I would not have an opportunity to take it to council for input.
Okay, well, so effectively, I mean, with that vote, the council is rejecting this bill. So I'll move with withdrawal. Does that require a vote?
There's a motion and a second for withdrawal. All those in favor say yes and raise your hand. Yes. Opposed, no. Motion passes. We are now on Councilor Harris, P3.
For the sake of putting this on the floor, I move a due pass of P3. I don't know if there's a second. And then I heard from Common Cause, maybe I'll, did they sign up to speak? Ms. Ferguson? Is there a speaker on this bill?
Yes, so if you'd like, Councilor Harris, we can go to public comment before,
Yeah, why don't we hear from public comment? Because I think there's some different feeling among the activists about the people who support ranked choice voting, and they have different opinions about this proposition. So I'd like to hear from the public.
I think we actually need to put the bill on the table first. So you made a motion?
No, I just made a motion for a due pass, and then we're going to, and then I didn't make a motion to table. What do you mean?
No, a motion for a due pass?
I made a motion for a due
Okay.
pass.
There's a motion and a second. So with that, we'll go to our first speaker, Heather Ferguson, followed by Candace Bauer, followed by Steve Kabidas.
Cabillas.
And then Eric Shimatmoto.
Thank you. Thank you, City Council. I'm Heather Ferguson. I'm the Executive Director for Common Cause New Mexico. And I would first really like to thank all of you for the amount of time and effort that you have spent on the issue of ranked choice voting over the last months. And then also especially thank Councilor Harris for his work in working with us and talking with us even today on this ballot question. So I would like to just first state that we're discussing our position right now from language that was amended in the meeting on June 17th by the City Council. But the amendment and the amended language is not posted online anywhere for the public to be able to follow along if they're watching at home, or for any of us to have. So I happen to have a copy, but the amendment itself is not actually posted online. So I would first like to say that Common Cause New Mexico and Common Cause at our national level, we love ballot initiatives. We would do ballot initiatives all day, every day, twice on Sundays, and I would love to have them at the state level. That is pure democracy and citizen action. And that is something that we would love to see. But what I'm going to mention is a concern that we have, a few concerns actually. So first is that we feel that as it is currently amended, but not posted online, so I'm just working from the amendment here, is that we feel that the ballot language is vague. And while we understand the intention in doing so, we also got to see in the Secretary of State's hearings that were held right here in these city council chambers last week on her rules for ranked choice voting, that there are a number of issues around how much the concept of ranked choice voting or instant runoff as we know it is misunderstood or not understood. And we really need to make sure that the public is clear. There was a lot of misinformation that was stated by members of the public, even just not understanding what ranked choice voting was, what the process is. And so I spoke with Councilor Harris, as he mentioned earlier today, which thank you very much for taking my call and for talking with me about this. And one thing that we had discussed was that there could be a potential to look at this for the 2020 county ballot, which would allow more time for that important education work for the voters. And I will be happy to take any questions. Thank you.
So I'll ask some questions,
Thank you.
Ms. Ferguson. So it sounds like that the people who are speaking out against it were pretty much sort of the conservative side. But if there's a lot of energy behind that, it could potentially, and there's some people on the other side too who don't like it. So if there's a genuine concern that it's not understandable, it's confusing, and if there's some energy put behind that, are you concerned that ranked choice voting initiative could fail at the ballot box?
I think our main concern is that we want to have an informed electorate, and I think what we did not understand until we got to hear what the public statements were from both sides. You're absolutely correct.
Yeah.
There were some from the conservative side, there were folks from the moderate side, there were several city council candidates that spoke as well down here in Albuquerque They also had hearings in Santa Fe where they spoke about it, and down in Las Cruces. And with all of that, it seems like there is just a generalized concept that the public doesn't understand exactly what ranked choice voting means. They don't know whether or not it means that, what if they wanted to only vote for one candidate? That was one of the concerns that we heard repeatedly stated. And if so, did they have that option? It's not clear in the ballot language as it stands right now, and we would have to try to look at what would potentially be having a bill that would go through the process, or that would be going to the ballot, and early voting begins, I believe, on October 8th. And so that would leave approximately 30 days to try to educate the entire electorate of Albuquerque what ranked choice voting is.
And
So I think that right now we have concerns. I don't know whether or not it would pass or fail.
And another option that we talked about is having an ordinance pass. And I wouldn't support that because I think the public should vote on how they vote. But I think there are some counselors who'd be open to passing an ordinance on ranked choice voting who voted against the ordinance because the ordinance came up during an election, and some people thought that could be perceived as changing the rules during the game. So I think, so your concern, and I think I agree with you that if you really didn't want ranked choice voting to happen in Albuquerque, maybe put it on the ballot hoping it'll fail, because that would really make it difficult for council to pass an ordinance at that point, even though we probably could, or put it on another, or do it again. So I'm thinking that's your main concern, is you want it to be successful. Is that, am I reading you correctly?
We strongly support ranked choice voting, absolutely. And we do want to ensure not only its success, but we want to ensure that the voters know what exactly it is that they're voting on when they look at their ballot, or have language that they can refer to that would also lead them to understand what the intent is, or what the definition of ranked choice voting is and what it does.
Okay, I have no further questions.
Counselor Sanchez.
Thank you, Madam President. You made the comment about not having enough time, and I, can understand your concerns, but you're saying we should put it on the 2020 ballot with the county and the state. We in the past have tried to get initiatives on the ballot in 2020 as a city, and it's up to the county commission, not to the city council, unless with the EU state law that has also changed.
Madam President, Councilor Sanchez, yes, with the new state law that has changed, the city now can, as a matter of right, put a ballot question on the state ballot. It will be the last question on the ballot, but the county commission can't keep it off.
Thank you.
Any other discussion, Counselor Borrego?
So I just wondered if there has been any effort to educate the public, and is there an effort with the county, do you know? Or, public education of what ranked choice voting is?
So Councilor Borrego and members of the council, Councilor Harris, when we had this discussion about the possibility of looking at a 2020 ballot, it was something that we had just had a discussion about this afternoon, about whether or not that would be possible. It would certainly allow for a lot more time and outreach for the public to know what was coming on a ballot out in 2020 than it would be in just a few months from now.
Thank you.
Thank you.
So next speaker is Candace Brower.
Good evening, Madam President and City Councilors. My name is Candace Brower, and I'm from District 4, and I'm here to express my concerns about the proposed Charter Amendment P-19-3. These concerns are shared by others who have advocated for ranked choice voting in the past but could not be here tonight and have asked for me to speak on their behalf. While we favor ranked choice voting for our city, we have reservations about putting this issue to a vote in November's election. We don't believe this gives enough time to educate voters about ranked choice voting so that they can make an informed decision. Deciding whether ranked choice voting is a good idea requires more understanding and knowledge than just how to use it. In talking to voters about this issue at the public library, we found that many had never even heard of ranked choice voting before. Furthermore, the ballot will already be very crowded with other questions for voters to consider. Finally, we are concerned about the amendment to the bill that would give the City Council the authority to change the rules for ranked choice voting up to 6 months prior to an election, since it could produce the same kind of conflict of interest that caused so many to reject the earlier ordinance for ranked choice voting, 054. For all of these reasons, we are asking the City Council not to put the proposed charter amendment on the ballot this fall. Thank you.
Thank you, Steve. And then Eric Shimamoto.
It's a very disappointing evening. I will tell you that I am a huge supporter of ranked choice voting. I think some of the arguments about not enough time for education, I find that on all these ballot questions, there's no education until the mailers go out 1 month before the election. So, that to me is not as good of an issue. There is a lot of education that needs to go on about this. This is true. But that's going to be true about democracy dollars as well. I'm a little upset at the revisionist history I'm hearing right here from only 2 months ago. I know we all practice revisionism at some time, but there was a vote to have an ordinance. And there was also a wise amendment from Councilor Gibson to delay that for the implementation of that for 2 years. And with that in place, those excuses went away, and that didn't happen that night. And so I'm a little bit disappointed, Councilor, that you're saying something happened that didn't happen, and that you're saying that you supported in a certain way when you didn't. So this is a great case of how we take something simple, we twist it, we turn it, we smash it, we cut it up into little pieces, we put Scotch glue and glitter all over it, and then dump it in the trash, and then no one's going to vote for it. This didn't have to be this hard. So yeah, with that amendment that was putting in your last committee hearing, you've put a poison pill in this thing anyway. Having the city clerk mess with stuff when we're going to have state code that sits solid for all municipalities is going to run into rocks anyway. I guess vote no, and let's hope we do this better next year.
So our final speaker, Eric, and I won't massacre your name for the 4th time.
Thank you, Madam President and councilors. I'm Eric Shimamoto. I live in District 2. And with regard to ranked choice voting, I first want to thank my counselor for being responsive when a group of constituents approached him and asked that he sponsor and support a ranked choice voting ordinance. So put on the record that I appreciate Councilor Benton's representing our voices in that way. I am also echoing Candace's sentiment that I'm disappointed in the path that we're on now. The state legislature did vest this body with the authority to adopt a ranked choice voting system by ordinance, and I think that up or down vote, and I think the way that vote went, Steve expressed his frustration. I felt some of that. And instead, I do feel that we're on a path to proposing a convoluted question to voters to ask us whether we'd like the city clerk to make a proposal that this body may adopt, and then if it does, could modify every other year thereafter. I think the language is confusing, the way that it's headed toward the ballot right now, and so I don't support that, and I urge you to not put this on the ballot in the form that it's headed now. Thank you.
Any discussion? Councilor Benton.
Yeah, just as the sponsor of the bill to take action ourselves, I do think that's still the right path, because I think it's a confusing, I mean, the education can occur. I'm not saying it wouldn't pass with the voters, but it does not, I agree with those who said it does not have to be this complicated, and that we should take this on ourselves again and consider this again and work again with the advocates to try to get it on at the next municipal election. And so the points have been made. I kind of agree on a couple of fronts that, and they're sort of diametrically opposed. One, where we, I think, should act as a council and come up with the best system and go with it. And then another where we're just talking about sending a simple matter to the voters and through procedural maneuvering refuse to even allow an open debate about that. So,
Councilor Davis.
And I'll echo what Councilor Benton said. I'll vote for the amendment to do the title and the summary in case this actually does make it to the ballot, but I don't think this is the right strategy. I think as someone mentioned, the legislature gave us the authority to do this. I think we should do it. I don't think it's our job as counselors to defer hard questions to voters every time we want to do that. I think we ought to do that, and, you know, as somebody who was a proponent of this and lost, I think we leave that on the dais and we come back in the next council the next year and we have that conversation with the community. But I do think that the proposal as drafted, even with this new title, is just, the process is too convoluted, it's too fraught with too many other pieces of process, and I am concerned about the voter education piece. Having worked on these ballot initiatives and run them, and I know the good work that Common Cause and Fair Vote and others do, I also know tremendous amount of work it takes to educate voters and a huge amount of money that is required to do that. I'm absolutely certain, without asking the city clerk, that we don't have money to do that, and I know we didn't appropriate it. And I'm fairly certain that our friends in the community don't, it would be extraordinary to lift, whether you're for or against, to organize the army you need to educate and knock on enough doors to educate voters about this, or to buy enough TV ads and everything else. And so, because I'm a proponent of ranked choice voting, I want to see us have a real conversation, a real debate based on facts and the opportunity to engage, and I don't think doing this at the last minute does that, and so I'd prefer to come back next year and try again, even if we lose. So, thank you.
Counselor Harris for
Yeah,
amendment number one.
well, I think I'm probably going to withdraw the proposition, but I want to clarify a couple things. Is that first, I didn't mean to misrepresent the record. What I meant to say is that I think the failed by a 5-4 vote, and I think there's a chance of picking up one of the counselors if it's not actually during an election. It won't pick up me because I think it's not something, because I think we need to send this to the voters. I think it's very important that the voters decide how they vote. Fundamentally, I just think they should. And maybe a very simple question that says, is the city council authorized to implement ranked choice voting? Just a sentence like that would be better and give everyone a chance to educate the public on what that means. But I think that the ranked choice voting should be given a chance, and passing this proposition, after speaking with Ms. Ferguson today, I realized that this might actually be the worst thing for it, if for those people who really want ranked choice voting. So for that reason, I'm going to move a withdrawal of P3.
There's a motion and second for withdrawal of P3. All those in favor say yes. Opposed, no. Motion passes. We are now on Counselor Benton, 052. Do we need to suspend the rules real quick, or?
I'll move a suspension of the rules until 11:45. I think our bet earlier I've already lost that bet.
Counselor Winter still in the running. So there was a motion and a second to suspend the rules to have the meeting adjourn at 11:45. All those in favor say yes?
Yes.
Opposed, no. Motion passes. Counselor Benton.
Thank you, Madam President. 052 is amending the Integrated Development Ordinance, Section 1416.35J3, Old Town Historic Preservation Overlay, other development standards to allow increased types and amounts of signage in Old Town, and to incorporate outdoor display and demonstration into Old Town HPO 5. I move a due pass.
There's a motion and a second for due pass of 052. We have some amendments that are in the iPad, and I think we should move the amendments before we go to public comment. We have two people signed up to speak.
And I'm not at the right place on my iPad, so I will move amendment number 1 and then ask Ms. Morris to explain it. Right place.
Ms. Morris.
Yes, Madam President, Councillor Benson. So the first amendment up has an A on the top corner. This one would add a dimension for two very particular types of signage in the Old Town area. There are signs, an additional sign allowed for premises with more than one establishment. So if you think about Old Town, that would be one of those, the properties where you've got lots of little individual units all kind of running off of the street around a courtyard. That's all one premise, but it's got maybe 5, 6, or 7 different businesses back there, establishments. We have a sign size limit of 25 square feet for that additional sign. It's basically for a type of directory signage so you can see who's back there. But we do not have in there a size limit for each individual establishment. The H1 zone under the old code had a limit of half a square foot for each of those. And so what we're proposing is that there should be some limit per establishment, but we felt that 2 square feet made the most sense. That's generally about the size of what those signs run at, based on font sizes and the dimensions of 25 square feet.
That's floor amendment number 1?
That's floor amendment number 1.
So all those in favor of floor amendment number 1, say yes.
Yes.
Opposed, no. No. Motion passes. 8 to
And
1.
Madam Chair, I'll move floor amendment number 2. And this is for discussion only at this time, and it is labeled in your iPads as B. And this would revise the title as follows: amending the Integrated Development Ordinance section for Old Town, HPO, and other development standards to allow increased types and amount of signage, et cetera, as it was before, and adding this to the key piece, and amending the IDO section to make tap room or tasting room a conditional use in the Old Town HPO 5. And then it adds a new section 9 to the ordinance, renumbering subsequent sections, strike the existing text and replace the following: where allowed, tap rooms or tasting rooms is a conditional use unless accessory to a restaurant. So this did come to us from some stakeholders in Old Town. And in the Old Town HPO 5, there are some regulations that are specific to the area rather than to the underlying zone category. For example, bars and nightclubs are prohibited, and restaurants are permissive no matter the underlying mixed-use zone. Most of the Old Town HPO 5 is zone MXT. Outside of Old Town, tap room or tasting room is conditional in the MXT zone. So a tap room or tasting room is defined in the IDO as explained on the amendment. And did I miss anything there? So that would be floor amendment number 2, and I will move that for discussion.
Second.
So there's a motion and second for floor amendment number 2.
Right. And then procedurally, I'm just reading my script here, but do I need to withdraw anything, or at this point, we're just deferring? Okay, so I'm going to, now that I've moved that amendment and we've heard it, and there can be discussion on it, and so I welcome any discussion on it, but long story short, there is an industry of as we know, throughout the city that's booming, of tap rooms and tasting rooms, and these include not only microbrewery type facilities, but beer and wine. This would not be for production, but rather as a tasting room, as it exists elsewhere in the IDO. And it would be, as elsewhere in the IDO, in Old Town would be a conditional use. So welcome any discussion, and then I'll move, and we'll have to, because of the situation, we'll have to move a deferral until September 4th after this.
So is there any discussion on floor amendment number 2? No discussion?
So I'll move deferral. I'll withdraw the motion on amendment 2. I don't think that requires a vote. And then I'll move deferral until September 4th.
Second.
There's a motion and second for deferral until September 4th of 052. All those in favor say yes.
Yes.
Opposed, no. Motion passes. Councilor Benton, 064.
Thank you, Madam President. This is amending certain portions of Chapter 6, Part 5, Article 6 of the Code of Ordinances known as the Complete Streets Ordinance to incorporate higher standards related to the implementation of complete streets within the
I need
city.
to go back. I actually,
sorry.
we had some people signed up to speak.
Oh, I'm sorry.
So I apologize for that.
And-
So we are going to go back to 052. I apologize that we deferred it and did that ahead of time, but we had to, I think. So we have, this is Sylvia Ramos and Jesse Ehrenberg.
Madam President and councilors, I am Dr. Sylvia Ramos. I am one of those few people who actually owns and lives in a house in historic Old Town. As is true of everyone who owns property, lives in, or has a business in Old Town, I want Old Town to not only survive but thrive. I am concerned that major changes are being made to Old Town that take into account the needs of businesses but not of residents. What may be needed are less dramatic actions, such as paying more attention to the appearance of Old Town and consistent enforcement of ordinances and zoning laws. A quick walk around Old Town reveals deteriorating buildings with cracked walls, rotting vigas, sagging roofs, dirty sidewalks, lack of even basic landscaping, and more, among other unsightly conditions. Having been a tourist all over the world, I know that a place that looks run down is not a place I want to venture into, even for a great meal. The council seeks to strike a balance between the need to increase visibility of retail shops in Old Town and maintaining the historic nature and integrity of Old Town. Yet I didn't see anything in the Exhibit 1 that preserved the historic nature and integrity of Old Town. What I did see is an increasing number, size, location, and variety of signs permitted, all of which will turn a historic adobe town into a colorful and jarring carnival of competing signs and may do nothing to benefit business in Old Town. Exhibit 1 has a sub-area just around the church and plaza with somewhat stricter standards. I believe the effect of this sub-area is that historic Old Town will be shrunk to the area within a 150-foot radius of Plaza Park. That's a long cry from the 300-year-old village that has been there. I ask the council to reconsider these changes and support taking smaller steps than those being proposed. Doing that may actually yield greater benefits for business owners and residents. Thank you for your careful attention, even at this late hour. I have submitted a letter with my detailed comments.
Thank you. Mr. Jesse Ehrenberg?
I am just a Albuquerque resident, and the reason people go to Old Town is to see an old town, the same way they go to one of the pueblos. And I understand that business owners want bigger signs, but I think they're killing the golden calf. So that's all I wanted to say.
Thank you. So with that, we are on 064, correct?
That's correct, Madam President, just quickly.
And we have 6 people signed up to speak.
Yeah, are there additional people here to speak?
Yes, on this matter, on 064.
They're still there.
So, do you want to move your amendments first and then,
Well,
yeah, move the bill and then the amendment?
well, we're still on, we're not.
No, we're on
We just heard the
064. We had
public
already
comment.
voted on that.
Yeah,
We
I'm
did the
sorry.
public comment,
So so I just wanted to point out, though, that
Does anyone have B12? No.
for those who did speak, we appreciate it, and that we will have the intention of deferring is also that we have a full discussion about this and how the process came about. So now we're back on our the
064.
064. And again, this is the complete streets ordinance, and I did move a do pass, or I will move a do pass. The
So
motion is-
motion and second for do pass 064.
And we do have 2 amendments to 064. And it is late, and it's terrible to rush something like this. We've done a lot of work with this, with the advocacy community, and we're going to hear from some of those who have patiently stayed with us tonight. but I would like to move the amendments. So I'll go ahead and move amendment number 1 labeled A in the bill book, iPads, and this would be amendment number 1 on page 8, line 16. After the sentence ending in the word disabilities, add the following content. The low to moderate income community criteria is one of the many factors that shall be taken into consideration when identifying and selecting project prioritization under this ordinance, and shall not be the sole determinant. Other factors of criteria that shall be taken into consideration include traffic fatalities, aging infrastructure, creating safe and efficient access for older adults and people with disabilities, and any other factors that enhance and improve public safety and health. So, the bill does have language about disadvantaged and underserved communities and their need for complete streets and for ability to use alternative modes of transportation than just an automobile. But concerns had been raised about what about areas that may not be underserved or disadvantaged, but that contain these specific groups of people who do need transit. And every district has certain areas where the infrastructure is substandard. So it's really pointing out all those factors and issues where, situations where traffic has increased and so forth. So that's what amendment number 1 is.
There's a motion, a second for floor amendment number 1 to 064. All those in favor say yes.
Yes.
Opposed, no. Motion passes. Amendment number 2.
And then I'll move floor amendment number 2. This is on page 11. Amend the section as follows. The administration shall work with the City Council to develop a process for implementation of Complete Streets policy to include performance measures, project evaluation, and staff training. This implementation plan shall also consider an active transportation coordinator position and an active transportation advisory committee. The committee may be an existing committee or reconfiguration of an existing committee and able to coordinate access across multiple departments. And we've had this discussion with Mr. Ryle and Ms. Nair about the idea of an active transportation coordinator. This is something that was brought forward by some of the advocates and also the Complete Streets advisory team who has worked a lot on this. And really the idea, while giving the administration some latitude to figure out how this would happen, that this idea of cross-departmental cooperation is pretty important to make Complete Streets successful. So that's what amendment number 2 is about.
So there's a motion, a second for floor amendment number 2. All those in favor say yes.
Yes.
Opposed, no. Motion passes. I just have a question before I say we're back on the bill and ask the public, ask for public comment. Does the Complete Street, just because I'm so tired and I don't remember, but do we reference the ADA Act in here at all, or compliance with it?
Madam President, yes, in the ordinance that Councilor Benton sponsored in 2015, which this amendment builds upon, it does mention the ADA Act, and folks with ADA disabilities are certainly called out as vulnerable users who do need to have safe access to streets, and that's one of the populations that this amendment to the ordinance proposes to prioritize.
Awesome, awesome. So with that, we are back on the bill, and I'm going to ask for the folks for public comment. So Mahesh, Sita, Sandra, and then Sarah.
Madam President, before we start public comment, I'd like to suspend the rules and extend the meeting till midnight.
Counselor Winter won. All those in favor extending the...
Wait a minute. This is to extend the rules. There's not a single thing here that can't be closed. I'm going to vote no. Let's shut this down. We can close it. I'll go home. There's not
We're at the finish line here.
Yeah.
There's a motion
So,
on the floor.
Yeah, midnight. All those in favor say yes.
Yes.
Opposed, no. Motion passes on an 8-1. So welcome.
Madam Chair and members of the council, and my name is Mahesh Sita. I'm with the American Heart Association, and we've been working on this bill with our coalition partners, AARP, the Cancer Society, and other folks from the tobacco industry as well as the health industry. And we want to thank Councilor Benton for carrying this ordinance, and also the administration and the mayor for willing to work with us on this important piece of ordinance. I mean, the bottom line is this ordinance is going to improve safety in Albuquerque. And apart from that, it's also a good public policy initiative that will help people to be active. And, if they want to take a walk, ride a bike to a neighborhood store or park on a weekend, go get a burger or an ice cream. I think this promotes healthy living lifestyles. So we strongly support this bill, and we thank all of you. I met with all of you, and you were very gracious in listening to us and asking good questions. So we thank you for that, and we appreciate you passing this ordinance. Thank you.
Thank you. Sandra. Followed by Sarah, and if you can come to the front and be ready to speak, there's some seats right there, and then followed by Carol.
Thank you, Madam President and members of the council. I'm Sandra Adendakis. I work for the American Cancer Society Cancer Action Network, and we, of course, are supporting this update to the Complete Streets ordinance because it helps our community have access to physical activity as a matter of course, as part of their transportation or as part of their recreation. And we would like to continue to make the healthy choice an easier choice for Albuquerque residents, and so we would appreciate your support. Thank you.
Thank you. Sarah E. Jadi. Sarah? She's gone. Carol Encinias. She's gone as well. Buffy Saavedra.
Good evening. If I extend this, Mr. Harris, we could say good morning in about 22 minutes. So he's not listening. Hi, good evening. I'm Buffy Saavedra. I am a District 2 resident. And I am here as a state director for AARP New Mexico. I know we've been here before. We want to thank you all for passing Complete Streets. We are really appreciative of the amendments made. AARP nationally actually focuses on livable communities, and part of livable communities means we have walkable communities, communities where we can cycle, where we can feel safe. I grew up in an area where we had no sidewalks. We still don't have sidewalks there, but maybe that's coming someday. But I really wanted to thank you and our team here. We have our advocates, our volunteers here with us tonight. And we're very hopeful that not only with Complete Streets that this focus on livable communities doesn't end, that we continue to think about that for all Albuquerqueans, regardless of where we live and what walk of life we are. So thank you.
Thank you. Buffy Saavedra. Oh, I'm sorry. Lucille Long. Lucille Long. Okay, so that is it. So we are back on the bill as amended. Councilor Benton.
Well, thank you, Madam President. It's kind of anticlimactic to be here late at night with everybody bleary-eyed, but I do think it's time for us to get this passed. I do want to thank Mahesh and the folks at the Heart Association and everyone who advocated over there, and AARP and the Cancer Society, and they're gone now, but Mr. and Mrs. Gonzalez spoke so eloquently about their loss and how about policy changes like this can help prevent tragic losses like they experienced. But importantly, it's all about making the city a more sustainable and a resilient city for the future. You know, times are changing. There are new generations of people who are not that interested in driving everywhere. But no matter what mode of transportation you use, it's important that you have fair facilities and fair access to ability to be mobile. So we've also had young people coming down here talking to us about needing to use the bus more often. All of these things are involved together to make this city more resilient going forward into the future. So I thank everyone who's been an ally in this, and I urge your support.
So there's a motion and a second for a due pass of 064 as amended. All those in favor say yes.
Yes.
Opposed, no. Motion passes. Congratulations, Councillor Benton.
Thank you.
This was a really good ordinance. So Councillor Jones, Benton, 065.
I'm worn out.
Thank you, Madam Chair. This is 065, adopting zoning conversion rules for properties in Batch 1 of the Phase 2 zoning conversion effort. This is what planning has been working on for months now, as promised. Does anyone have any questions, or are you okay with this? Let's go.
No questions. So there's a motion.
So move approval.
There's a motion and a second for 065. We actually have 3 people signed up to speak. Ms. Loretta Naranjo Lopez.
I think we have some amendments first.
Oh,
Right, there are
do you?
amendments.
Oh, yes, you do. I'm sorry. I apologize for that. If you can hold on one
I don't have
second,
it with
Ms. Loretta.
I don't have amendments.
So do we have the amendments? It says we have amendments in our.
Madam President, yes, they're in your iPads, but we can also hand out some extra copies.
That would be great. Thank you.
Okay.
Thanks, Crystal. Okay, so this is marked A on the corner. It is a floor amendment number 1 to Exhibit X to O1965, and it's revising Form ID number 19 to read as follows. In 1973, a zone change for this property was approved for the P2 zone. However, when this was mapped, it was only mapped on the northern half of the property and not the entire property, creating a floating zone line. In 1990, the portion zone B2 was converted to SU2P per the Martineztown Santa Barbara Sector Development Plan. Under the IDO conversion rules, the SU2P zone was converted to MXT. That's perfectly clear. So basically, this was a cleanup of something that had been zoned in the middle of it since the 70s, and now it is all under one zone. So are there any questions, councilors? I would move approval of floor amendment number 1.
There's a motion and second for floor amendment number 1. All those in favor say yes.
Yes.
Opposed, no. Motion passes.
And the next one is floor amendment number 2, which is marked B on the exhibit. In Exhibit X to O1965, strike through the text for Form ID number 4 and add the following note. Removed at City Council 8519 as property deemed ineligible, the property is not a non-conforming use. And then the second one is in O1965, page 7, beginning 1, add the following new whereas clause. Whereas Form ID number 4 was removed from the Batch 1 properties for which City Council will consider adopting zoning conversion rules. This property was deemed ineligible for the zone conversion process. It is not a non-conforming use and does not meet any of the other criteria. So this is just a cleanup of something that got stuck into a change that shouldn't have been there. So I would move approval of floor amendment number 2.
All those in favor of floor amendment number 2 say yes.
Yes.
Opposed, no. Motion passes. Back on the bill, 065. Are we
Thank you.
ready for public comment?
Then I would move 065 as amended.
So there's a motion and a second for 065 as amended. Our first speaker is Ms. Loretta Naranjo Lopez, followed by Paul Weaver, and then Athena Christodoulou.
So President and councilors, my name is Loretta Naranjo Lopez, and I'm the president of the Santa Barbara Martineztown Neighborhood Association. And the Association Appeals and Protests is the approval of the voluntary zoning conversion. And this was at the beginning of the process that we sent the letter for the record that number 4 and 19, we were not in favor of these two cases. I want to thank staff for meeting with me on these cases, and there were several of them: Carrie, Jacobo, Martinez, Daniel Serrano, and Whitney Phelan, and they were very good at working with me on this number 4 case. But number 19, as we see on this record, it states here that it was zoned SU2R1 pre-IDO, and then it went to 2 different zones. So I'm concerned about it because we really went through a lot of records on the first case, but number 19, I'm questioning it, because if you look at the record that we had here, it shows it with 2, I don't know if this is showing, but there's 3 parts to that lot, which is number 3 there on the description of the lot. And so it has section 2 that was changed to that P, which is a spot zone. As a professional planner that looked at zone changes, that would never have been approved through my recommendations because it was a spot zone. But besides that, it's saying here on the city's record that this was R1. And it clearly states that in 1973 it was R1. I'm not sure if we're looking at the right property. So I would like this to go to batch 2 so that we can get more clarification. I was able to get it through for number 4, but not for number 19. I think there needs to be further investigation.
Counselor Jones, you have a question? Then
No,
Counselor
I
Biden.
think that staff can probably answer this question, if you don't mind.
Madam President, Councillor Jones, yes. So the map that Ms. Loretta Naranjo Lopez had up shows the floating zone line, and so that map. So in 1973, prior to 1973, the whole property was zoned R1, as Ms. Lopez states. However, in 1973, the EPC approved a zone change for the entire property to change the zoning from R1 to P2. However, unfortunately, as shown in the map that was on that's up there right now, there was a mapping error, and the zone line was mapped for only the northern half of the property, and it left the southern half of the property with the R1 zoning, even though the EPC's action was for the entire property. This this mapping error, was not noticed until now. And so that mapping error created a floating zone line. So that property had 2 zones on it according to the map. The northern half, which was the P2 in 1973, and then later SU2P under the sector plan, and then MXT under the IDO conversion, was for the northern half, and the R1 was mapped at the southern half. So the amendment that you have before you would say that, yes, what the planning department recommended for the property is the correct analysis, because what we're actually fixing is a mapping error. So back in 1973, the EPC made the recommendation, whether it's in our eyes today, the right recommendation or not, that property should have entirely been changed to the P2 zone.
I would just like to refer to this map because it's saying 3 sections of that lot. And so it's stating section 2, but all of this whole lot there from Manal to that end of the lot line is single-family dwelling, historical. And we think, the association sees the MX zone as gentrification and displacement for our community. So we find this detrimental and does not protect the health, safety, and welfare of the residents. And so I'm saying that I disagree with her. It's not showing. And then she's even telling me on her record that this is pre-IDO SU to R1. And so they're recommending for 2 different zonings in the IDO. That's when they recommended 2 different zonings. I don't know. It's not clear to me in either of these maps, because one's saying this is section 2, so then there's 3 sections. The front part, the north part, the south part, and then the middle part, which is the P zone, which is in the file of 1973, stating that if amended, it had to have a drainage plan, and that it would have to satisfactory to the city engineer prior to.
Ms. Naranjo Lopez, may I
But this is important because in 1936, a building
Ma'am,
already
ma'am, you are
existed.
here only for
Yeah.
comment. We're not in interaction, but I do have a question. Ms. Naranjo Lopez, do
Mm-hmm.
you own this property?
No, I don't.
Okay,
No, it's
Thank
in
you.
the Martinez-Town, Santa Barbara boundaries.
Okay,
thank you.
And so
Counselor
I'm
Benton.
just letting you know that.
Counselor Benton.
Thank you.
And I appreciate Ms. Naranjo Lopez staying down here to testify tonight. And this is a complicated situation because of this line that was created in 73. I wanted to ask staff, let's say prior to IDO, what, with regard to the property owner, had the property owner wanted to do something other than R1 residential, what would have occurred with this site?
Madam President, Councilor Benson, it would probably have, if somebody had come in with a non-residential use for the property prior to the IDO, if it was on the portion that was in the northern half of it, technically they would have had the zoning. So I think that would have been a call for code enforcement to make how much of that property would have been allowed to be used for that non-residential use. It would probably have resulted in a request for a zone change. And I wouldn't be surprised if that applicant justified their zone change based on a mapping error, based on the history that's in front of us.
Yeah, so oftentimes these zone changes or even variances are based on errors and actions like that of government, right? So this goes back to 73. So yeah, most likely the owner of the property would have either had to build their commercial part on one side of the lot and left the line floating, is that right?
Madam President, Councilor Benson, it's hard to sort of second guess what we might have done in the past. They could have maybe just kept the use to the northern half. They could have maybe replatted and put in a lot line that matched the zoning, or come in for a zone change to tidy it up for the entire property. So there are a couple of different methods that they would have to address this if we didn't have this process in front of us today.
So, Madam President, just to be clear, this type of mapping error this isn't the first time it's ever happened, because we've seen this type of floating line in the past.
Madam President, Councilor Benson, yes, that's why it's one of the categories is that floating zone lines do occur. They occur for a variety of different reasons, and mapping error is one of them. Mapping errors are relatively rare, but they do exist. Our mapping layers go back many years, and record keeping has varied over the years. We have a very, I think, solid basis for our mapping today, but when you have a city with a history as long as Albuquerque's, it's not unexpected that over the years things will come up that we'll realize where there's an error or something that needs to be corrected.
Councilor Sanchez.
First, I'd like to apologize, but I'd like to move to suspend the rules and extend the meeting till 12:20 a.m.
There's a motion and a second to extend the rules to 12:20 a.m. All those in favor say yes.
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 Opposed, no. Motion passes.
12:20 a.m.
So, Madam President, I still make a motion to approve as amended.
So we have two more public speakers, so Paul Weaver and then Athena.
Thank you. Madam President, ladies and gentlemen of the council, thank you for your time. My name is Paul Weaver, and I'm a new resident to Albuquerque. After 18 years of military service, I'm happy to have found a home and a nice neighborhood to put down some roots for my family and my children to grow up in. I was surprised upon purchasing my house to learn that an apartment complex is planned for development right behind the fence line of my single-family home. As it turns out, this is being rushed through the planning process before the batch 1 and batch 2 approvals can go through. So in essence, while my section of the neighborhood is zoned for an MXT, they are impending some residential changes, conversions with this batch 1. Developers are chomping at the bit to go ahead and develop while they are still on the transition between MXT and MXL. So to come to find out that in neighborhoods and districts across the city, developers are exploiting this window of opportunity to encroach on residential communities. The checks and balances that were in place with sector plans is undermined slightly with the IDO. Passing batch 1 and batch 2 would be a small step in restoring the protection of our communities from developers that are sort of bullying neighborhoods into development and encroachment. Instead of large apartment complexes, communities would no doubt prefer something more consistent with the areas in which they currently are in. Obviously, passing batch 1 for my neighborhood, although not for every neighborhood, would maintain the neighborhood characteristics, and we would be in favor of that. And if you were to put this on hold or delay this decision, would you also be delaying the decisions of the development projects that are in those neighborhoods, or would those keep going forward? Or would you be considering those on a case-by-case basis? So I thank you for your time, and thank you very much.
Thank you. Athena?
Madam President, councilors, this was a lesson in perseverance. I would like to point out that I am also in District 4 and am addressing Batch 1 approval because of the Barstow and Alameda project, the multi-family, which is much more dense than it should be because, again, developers are taking advantage of the old zoning, not the true zoning, and the lapse before that true zoning is approved. So I encourage you to preserve our neighborhood stability and land use predictability as the IDO is supposed to, and approve batch 1 so that the intent of the IDO is realized. Support 065. Thank you.
Thank you. Councillor Jones and Benton to close.
Thank you. We appreciate the staff and all the planning department for making this possible to get our city back onto a cohesive planning code. So I urge your approval.
So all those in favor of 065 as amended, say yes.
Yes.
Opposed, no. No. Motion passes 8-1. Councillor Benton Winter, 070.
Madam President, this is 0-70, amending Chapter 9, Article 4, Part 1, Section 8 of the revised ordinance of Albuquerque, the police oversight ordinance regarding case review by subcommittees of the Board of the Civilian Police Oversight Agency. I move a due pass.
There's a motion and a second for a due pass of 070.
Madam President, I think we have a couple members of the committee who would like to speak, if you don't mind. I don't think, did you sign up? Okay, sorry, thank you.
I have one person signed up. Valerie St. John. So, okay. Yeah, Councillor Winter, yeah, so we did a motion and a second for a due pass of 070. There are no amendments, so we're good to go? Okay.
Okay, ready? Okay.
If we could have one of you just sit down while one
Can I
speaks.
defer some of my minutes to her, because she got here late to sign up, or she's the co-chair?
We only have 2 minutes, so.
Mine's real fast.
But I would also like to give Ms. Fine the opportunity to speak. She's been waiting here till midnight.
Right, right.
Okay, let me go ahead. Madam President,
Is there-
Council?
Yeah.
My name is Valerie St. John. I currently serve on the Police Oversight Board, and I chair the Case Review Committee. Also with me this evening is Joanne Fine, and she is co-chair of the board. And I would like to personally thank Councilor Benton, Councilor Winters, and city staff for spearheading the amendment to the Police Oversight Ordinance. This will reaffirm the role of the Case Review Committee in providing timely resolution of a citizens' grievance brought before the POB Board. Thank you.
Hi, I'm Joanne Fine. I just wanted to thank you myself because without the Case Review Committee, we had a special meeting, which is what, without this amendment, we would have been doing. And we went through over 40 cases in 19 minutes. The problem with that, as your amendment shows, is that we do not bring the public with us if we don't explain what those cases are. And that's what Case Review does. It drills down on what it is that we're receiving as complaints. It talks about what the policies are. It educates the public and the community about what's going on in Case Review. And that also applies, to serious use of force and officer-involved shootings. So it's really important that we be able to have this committee because without it, we are shooting ourselves in the foot in terms of oversight. So thank you for doing that. I appreciate you.
Thank you. So,
Ms. Fine, I hope there is no pun intended on that last statement.
No pun intended.
so Councilor Benton
We're all
Winter.
punchy. It's midnight.
Councilor Benton Winter.
Thank you, Madam President. Well, first I want to thank my co-sponsor, Councilor Winter. We've been through the last couple of rounds on civilian police oversight and constitutional policing and the things that matter so much to our community. And I do want to thank Ms. St. John and Ms. Fine for their dedicated service to the board. You guys are real champs, and especially for sitting through this meeting tonight. So I urge your support.
So there's a motion, a second on the floor for due pass of 070. All those in favor say yes.
Yes.
Opposed, no. Motion passes. We are on our final item this evening, Councilor Benton, R162.
I feel guilty here for
What do you want?
having sponsored so many. I move a due pass on R162.
There's a motion, a second for a due pass.
And I think we had we had Mr. Sabatini speak about this. Just background, this is the corridor that had a relatively modern corridor plan under the previous zoning scheme. That plan was not perfect either. We still are going to have a community planning area process, and that hopefully will continue to fine-tune what goes on North 4th, which is a great old corridor, part of Route 66 itself. But I need to move a couple of amendments. I guess it's just one amendment. So I'll move floor amendment number 1 to R19-162. Actually, did I move the bill?
Yes.
Okay. Floor amendment number 1 to R19-162, and this replaces an exhibit. And Shanna, you want to? You're all fresh. I've talked myself out tonight. You could take it from here.
Madam President, Councilor Benton, I can make it very quick. This exhibit will replace the one that was in the original resolution. As we have moved through the IDO annual update process, we have proposed similar regulations, but some that are a little better, and we want what's in this resolution to match what we have proposed for the IDO annual update, so it just swaps out the exhibit with what we have proposed through that separate process.
Thank you.
So there's a motion, a second for floor amendment number 1. All those in favor say yes.
Yes.
Opposed, no. Motion 8-1. Got it. So back on the bill, Benton to close as amended, 162.
Thank you. I urge your support.
So there's a motion and a second on the floor to, for a due pass of R162 as amended. All those in favor say. Oh, I'm sorry. Didn't see your hand.
And I'm just going to vote no on this because I think that we spent a lot of time on the North 4th Street plan, and we have not given it really sufficient time to work. And I also think that by replacing our design guidelines, we are basically opening up another can of worms of creating sector plans all over again. So that's my comment. Thank you.
And Madam President, if I could just respond. Yeah, so these are interim guidelines only. We do have a process for continuous improvement with the IDO. I think that's really an important advancement that was made that we didn't have before. We would pick away at when we found deficiencies within the zoning code. We've got a continuous improvement process in place. This is part of that process and will ensure some improvement in the corridor over the previous sector plan. So when we changed our zoning system to the IDO, we didn't fix everything that was wrong with the old zoning code. That would have been too monumental a task, but we set up a procedure for amending it. So the idea that we have many amendments to it is exactly as planned. And we hope that continues with a lot of public involvement.
So is there any other discussion for R-162? I would just concur with Councilor Borrego in terms of just, one of the big issues that I had was the removal of sector plans, and as we go in and we're just trying to kind of fit sector plans in, I think it just not a good direction to go. So all those in, Councilor Benton to close, sorry. All those in favor of R-162 as amended, say yes. Yes. Opposed, no? No. Motion passes on 7-2. With that, there,
Madam President, my bet was 12:25. Can we stay here a few more minutes?
We still have 12 minutes to chat.
There be no further business. This council meeting is adjourned.